Item 60. Lordship, I pray that it may be taken up at 2 p.m. Your Lordship.
Why?
Already similarly placed accused persons, they have been granted bail by the Father.
Item number?
Item number 60, Your Lordship.
It will be taken on its own turn. Wait for the turn.
Item number 31, I've been appointed the amicus. My paper book I could not collect because I was out of station. The registry note says I need to take it from the court. I may be permitted to take it.
Yes.
Obliged.
Lordship, may I please, your Lordship? Lordship, I beg to mention a bail application for withdrawal.
Okay.
I beg to mention item number 41. I have been told that the case diary has not been received. It's an anticipatory application, my lord. There is no interim order. So I pray that a short date may be granted.
On request of learned additional public prosecutor KK
Maybe on
Parashar
8th of August.
for some more time for producing the case diary. This case is adjourned till
8th of August. There is no interim order.
yes, Mr. Parashar.
Udalgudi from
Minus
11th.
11.
We'll list it on.
All right.
My lord, I have to mention one criminal petition I have filed and got the filing number, my lord.
Yes, senior court.
Monday.
Senior court.
Wait, please, Your Lordship. Lord, I beg to mention for listing of two anticipated bail, fresh bail matters. May I prefer be kindly be listed for 2 months.
When have you filed?
Lord, it has already been filed on Tuesday, madam.
When?
Tuesday, madam, last
Tuesday.
yes.
Okay. Tomorrow.
I'm obliged.
May I please, your lordship? My lord, item number 44, my lord. This matter I find a small additional affidavit. Just it may be called to record kindly.
Okay. Call for the additional affidavit.
May I please, Lordship? I beg to mention for listing of regular bail, Lordship.
When have you filed?
Lordship, last yesterday left the matter, Lordship. I have filed before 30 days. Today, for today, for bail hearing, Lordship. Today, 52 days, Lordship.
Bail hearing. 5th of August.
Please, Lordship, I have to mention item number 13 for adjournment today.
Item number
13, 13.
Item number 13. Heard Mrs. Foucault, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. When
Any day after 2 weeks.
prayer is allowed, registry will list it.
Lordship, I beg to state item number 63 of the supplementary list.
63.
Supplementary list. Lordship, this matter ought to have been
We have sent it to the appropriate court.
May I please say, Lordship, I beg to mention item number 47 and 48 of the daily list, Lordship. Mr. Pipi, that the conducting counsel has some personal difficulty today, Lordship. The matter may kindly be taken up after 10 days, Lordship.
47 and 48. You have informed the other side. You have informed the other side.
Step back, Mr. Pipi, that he said the other side is not there.
PP. You inform also on request of Miss, what is your name? P. Sharma submitting on behalf of Mr. PP Datta. Praying for adjournment. This case is adjourned for today.
Maybe taken up.
Registry will list it.
Much.
Your Lordship, the regular bail application 2 days, 53 days.
When have you filed?
Leftover matter, Lordship.
What is your prayer?
Monday, Lordship.
5th.
Lordship, I like to mention item 40, Lordship. Due to medical emergency, Lordship, engaged counsel is out of station. So matter will be taken up tomorrow.
14.
40, 40.
Heard Mr.
A. Mohammed.
A. Mohammed
on behalf-
submitting on behalf of learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Place this matter in the next week on a date to be fixed by registry. No fixed date, no fixed date. Registry will fix it.
From the item number 1.
Yeah, please, your lordship. Lordship, the petitioner is seeking bail in connection with special POCSO case number 16/2024 pending before the Supreme Court. Lordship, 20 years where he's been in judicial custody for the last 543 days, your lordship.
Service,
Can
sir,
copy.
Service notice complete, otherwise can copy has come, my lord.
service is complete.
No, not completed.
You have taken steps.
Lordship, I've taken step.
You take information regarding
It is in the office note dated 15/7/25. 15/7/25 office note, step received and notice issued to the respondent
Okay,
number 2
okay.
to AP. Flag X.
but service report has not yet been received. You take information.
My lord.
Even the trial court also, lordship, they are not cooperating because for the last 20-25 dates, if a lordship will peruse. the
Let him
entire case
find
report,
out, let him find out whether the
the
notice,
are absent. For the last
notice
25 dates.
heard Mr.
Each month.
H. Majumdar, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Though the scanned copy of the trial court records have been received, however, office note dated 29/7/2025 shows that the service report in respect of notice issued to respondent number 2 has not yet been received. So, learned additional public prosecutor is requested to get the information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date. When?
6. 7.
You have to telephonically take information. Let this matter be listed on 7th of August.
Regular bail application lordship earlier was rejected lordship. And FIR will find page number 16 lordship and as on to the
Earlier it was rejected by this court.
slow lordship and the honorable justice Nandi lordship already declared.
What is the new ground? 22C, pending investigation.
Charge sheet submitted lordship, 5 witness already been examined lordship. And the statement lordship, there is nothing, any implication is made by the witnesses. lordship.
When were you arrested?
29/7/2023, as on today, lordship, more than 2 years. lordship. But other co-accused lordship already been granted bail and earlier occasion. lordship. I'm providing this order lordship.
What is the new ground?
5 witness already been examined lordship, but there is nothing made any adverse statement against the petitioner lordship.
Heard, Mr. We will call for the status report. Heard, Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Considering the fact that the petitioner has approached seeking bail before this court for the second time when his earlier application for bail was rejected, perusal of let a status report about the progress of trial of special NDPS case number 22/2023 be called for from the trial court. Let this case be listed on 22nd August. No,
That yes,
And Malat, up
Okay.
to PW five, they have annexed. But after that, if anything,
I have
that also may
I-
also.
okay, let the status report come. 22nd August.
Published, Lordship.
Your lordship. 483 application lordship. Lordship, this is a second bail application earlier rejected by Justice M.R. Pathak lordship.
What is the ground?
Lordship, new ground is lordship, non-furnishing of grounds of arrest lordship. 426 days behind bars lordship. Allegation is under Arms Act. Charges have been framed against me under Arms Act lordship.
What is the date of your arrest?
My date of arrest is lordship 01/07/2024.
7/2020.
01/07/2024.
Yes. We'll call for the,
Right.
you have furnished the notice.
It is on page 58. lordship.
It was not considered. You took this plea before the,
No, no, earlier it was not. there.
Earlier it was not. Earlier there was another concept.
heard Mr. P.K. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the scanned copy of the case diary of Bongaigaon PS case number 226/2024 be called for from the trial court. Let also a status report of the progress of the trial of sessions case number 73 of 2024 be also called for. Let this case be listed. 22nd August.
Deeply over.
Item 4.
My Peter lordship. It is a regular bail lordship. International case, Malwari case number 171, 2025. The accused was arrested on 24/6/25 and forwarded on
It is pending investigation. We'll call for the case diary. Mr. What is your name? Mr. D. Sharma, learned counsel for the petitioner. Also Mr. K.K. Parashar, call for the case diary. Let this case be listed on. Total
12.
12. 14th. 14th.
Item 5.
May I please? Case the accused arrested on 24/6/2024, Lordship, 422 days, Lordship. And the allegation is 370.
376.
With section 6 of Foxtrot, Lordship.
It is pending investigation.
No, Lordship. That's it.
Substitute scan copy has to come and notice has to be issued.
What is the stage?
Mr. Lordship, since very long time, Lordship, as it filed on 30/6/2024, and thereafter it was fixed on fixed for evidence, but till date there is no evidence was examined. Total evidence is 11 evidence.
Heard
M.A. Mundo.
Mr. M.A. Mondol, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the scanned copy of the case diary of Kazigaon PS case number 21/2024 be called for from the trial court. Let also a status report regarding the progress of trial of special POXO case number 157/2024 be also called for. Issue notice to respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent within respondent number 2 within 3 days from the date of this order, returnable on 26th August.
Complex.
Item 6.
Your lordship. My lord, FIR is page 18. In respect of Hatikau PS case, my lord, on receipt of terrible information by the Hatikau police, raided the house of the petitioners. They are Afghan national. And they were arrested on 22nd of June, my lord. And now they are in custody from last 39 days. Investigation is going on, my lord. So, see the
Case diary. What is the offense?
offense is, my lord, section 61, 337, 340.
What was-
337 is not bailable.
Passport and foreigner sector.
Rest, passport act section 12, representation of people act section 31 and 14A and 14B are all are bailable offense.
Which is non-bailable?
337. Forgery of record of court or public document, which is 7 years.
Heard Mr. I.A. Talukdar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Stop call for the case diary. Let this case be listed on 18th of August.
My lord, Hatigao, it is nearby. It is towards the direction.
The distance does not matter.
Several matters also fixed.
Shorten.
Not the-
14.
Like,
Item 7.
The petitioner behind the bar more than 31 days, lordship. FIR at page number 13. In this case, FIR or petitioner is not FIR named accused in this case, lordship. Allegation is that they are involved in the illegal online gaming and money was transaction.
Case diary would be required.
If co-accused already length of detention allowed this both on go on.
Heard
I have
Mr.
annexed it. Maximum punishment is 3 to 5 years or all are trialable by the magistrate lordship, CJM court.
Why your prayer was rejected? After perusal of the case diary.
Allegation only that his account was used by the some FIR named accused. This is the allegation against the.
Heard Mr. A.B.T. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Give a short date. 14.
8. Wait, please, your lordship. Lordship, this is a regular bail application, 28 days, lordship. 22 kg of beef, lordship, recovered from this hotel, lordship. I am the owner of the hotel, lordship. Ilya Hotel, lordship. And lordship, I have a license to lordship to run hotel, that is on page 19. And I have purchased that meat from a lordship, Ajat Meat Shop. It's also registered shop, lordship. That is on page 20, lordship.
Do we have authority under section 8?
Lordship, that section is not incorporated here, lordship. Only 13A, 13(1) is
No,
there.
13(1) is the penal provision.
Penal provision, but that was not lordship because of
But
selling.
do you have that license?
Lordship, regarding lordship sale, hotel lordship, I have a registered.
Not hotel. If it is within 5 kilometers,
Lordship, that lordship, otherwise lordship, this hotel run from 2023 lordship, no objection from that part lordship.
no, that cannot be a ground. When
Recovered.
that may be a ground.
Already recovered, seized lordship, 28 days lordship.
That may be a valid submission. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Muslimuddin, who has been arrested, who has been detained behind the bars since 2/7/2021 for last how many days?
It's
28
days.
28 days, bracket close, in connection with Laluk PS case number 127/2025 under section 61 within bracket 2, within bracket small a slash 298/299/196 within bracket 2 of BNS. Read with section 13 within bracket 1 of Cattle Preservation Act, Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 1/7/2025, one Rikumani Medhi had lodged an FIR before the officer in charge of one Chandan Fukan had lodged an FIR before the officer in charge of Laluk police station, inter alia, alleging that on receipt of an information regarding sale of beef at Ilahi Hotel situated at number 2 Karunabari, in violation of the provisions of Assam Cattle Preservation Act, a search was conducted, and during search operation 22 kgs of beef meat was seized from the said hotel, and the present petitioner was apprehended therefrom. You are the owner?
I'm the owner of the hotel lodge.
Learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 27 days, 28 days,
29 lordship is forwarded on to 7.
29 days. And the suspected beef meat has already been seized. And therefore he submits that further custodial interrogation may not be necessary. On the other hand, learned additional public prosecutor has prayed for
Usually because matlab udhar that license doesn't say that they can check this matlab.
has prayed for calling of the case diary. So I have considered these submissions made by learned counsel for both sides. It appears from materials available on record that suspected beef meat has already been seized, and the petitioner has been detained behind the bars for last 29 days, which, in the considered opinion of this court, is sufficient period to subject him to any custodial interrogation if same was required for the investigation of the case of such nature. Stop. This court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid case. So, in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority.
CGM
Subject to the satisfaction of the Chief Judicial Magistrate,
Lakhimpur, not
Lakhimpur, with following conditions, number 1 and number 2. This bail application is accordingly disposed of.
Highly obliged. May I please, but at this stage, my lord, learned trial court record may kindly be called for, it's a POCSO matter, my lord.
Heard Mr. Ved Kamar, learned senior counsel assisted by Mr. P. Dev Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Let the trial court record, let the scanned copy of the trial court records.
And my lord, that service of notice, I'll take step to the learned PP, my lord, in the course of the day.
What is the stage?
My lord, it is regarding Dr. Waliul's
At what stage?
evidence stage, my lord.
Let the scanned copy of the trial court records be called for.
Along with the
And
evidence.
let the notice also be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 2 days from the date of this order, returnable on
Whom should I take, sir? Normally, sometimes.
there is a notification, you follow that notification, PP. It will go to the registry. It will come to office of the shorter 22nd August.
Material also mine. My daughter Foxo is there, prohibition of child marriage is also there. But case is my daughter, she is my wife. And she was whether Foxo comes or not, my daughter. Very basic to my daughter. Because case was registered both DNS, child marriage and the Foxo. You also kind of say,
We'll issue notice if she is your wife. We'll issue notice if she is your wife, she may appear.
no, that is there, madam. My only question, my daughter, already 30 days, only short date, madam, because.
Oh,
Huh?
investigation is going on.
Already 50 days, madam. Oh, tax should file. Oh, tax should file. I'm sorry, madam, that I could not.
Heard
So in that
Mr.
case, my scan copy of the, along with the.
Heard
case diary.
Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the scanned copy of the trial court records as well as scanned copy of the Gauripur PS case number, scanned copy of the case diary of Gauripur PS case number 245/25 be called for. Let also notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice to the respondent number 2 within 2 days from the date of this order, returnable on 22nd. 18.
60 days, madam, already.
No, that
No, that is there. If it is come under child marriage, madam, 2 years, madam. 60 days are statutory.
no, that you have to satisfy.
That's the other scenario, but 14 maybe, madam.
Okay, 14.
Obliged.
You have to take steps, ensure
Yes,
that
today, it will go through the OC, my lord.
if she is your wife, she can otherwise appear
Yes.
on the next day.
But now she is under the influence of somebody else, my lord.
Those facts are there.
She's nature with somebody else, my lord.
14th.
But the one day, including 47, 48, it will come, I think, in the diary, man.
14th.
Child
Item, Timan?
out of 9 witnesses, only 2 witnesses has been examined, their lordship. Trial court records will call. Can go in the call for you.
Heard Miss S. Nazneen, learned counsel for the petitioner. Also heard Miss, what is
See you, Padre.
P. Upadhyay, learned counsel for NCB. Let the scanned copy of the trial court records be called for. Registry to take steps for requisitioning the scanned copy. Let this case be 22nd December, 22nd of August.
Item 12.
Please, your lordship.
Yes.
Item number 12 and 27 are out of the same FIR. The petitioner in item number 12, my lord. The lordship is holding 2440, bail application 2440.
Yes.
Yes. My lord, the petitioner is an agriculturist and he is also a pisciculturist. And he runs a farm in the district of Nalbari. Now, the allegation is that he has opened an ashram and thereby he is attracting devotees from
Hindu faith. And he is also doing some magical activities by which he wants to rid the people of various ailments and other things. And in the garb of that, he is taking money from the people at large. This is the sum and substance of the FIR. If your lordship will kindly come to the page.
What is the offense, section 6?
Offense is basically 318, 19 and 306, cheating and taking away money, extortion.
And what is section 6 of Assam healing?
Section 6, my lord. Section 6 is that, my lord, I'll pass on a copy, my lord. Penalty is whoever contravenes any of the provisions of this act or the rules made thereunder shall on conviction be punishable with imprisonment for 1 year, which may extend up to 3 years. And in case of a subsequent conviction up to 5 years, or fine or with both. Now the charging provision, your lordship will find that section 3. In the previous page, lordship. Subject, has your lordship got it?
Yes.
Subject to the provisions of this act, no person shall take any part in healing practices and magical healing propagation for treatment of any diseases, any disorder or any condition relating to health of a person, relating to human body directly or indirectly, giving a false impression of treatment to cure diseases, pain or trouble to the human health. Well, this is the charging penal provision of this act. Now, my case is that, my lord, I am not only a registered Ayurvedic medicine dealer, I am also holding a registered firm in which, my lord, I am carrying out activity of pisciculture. If your lordship will kindly come to page 18, I have enclosed my licenses granted by the government.
Page?
Page 18. On the right hand side top, just below the writings annexure D.
What certificate is this?
Well, this is a registration granted by the government, Registrar of Funds and Societies.
For?
For, my lord, the activities are mentioned here. On the top, right hand top, your lordship will find just besides the writing 14/11/2017.
Yes.
Government, non-government project, export and import of agar oil, agar wood products, fish production, fish farming, fish hatchery, nursery, plantation farming, dairy and dairy products, poultry farming and poultry products, farming, some this.
Where are you reading? Page?
Page 18, my lord. Page 18, top right hand corner, just below the writings annexure D.
Yes.
Well, this is, has your lordship got it, my lord?
Yes, these are.
Yes. Government, non-government project, export and import of agar oil. Agar oil, your lordship knows that, which is used for perfumery productions.
No, what is the accusation against you?
Now, accusation is that, my lord, in my farm, this is the farm which I have been running there. In this farm, my lord, I am inviting people and in the garb of giving them some healing treatment, like giving some leaves, giving some vegetations, etc.
Which is prohibited under this act.
Which is prohibited under this act. They are saying that in the garb of doing that, I am extorting money from them. Now, if your lordship will kindly see, the allegation is not by any individual. The FIR has been lodged by a sub-inspector of police. If your lordship will kindly turn to page 55, my lord, 55 is the FIR. Is your lordship got it, my lord?
Yes.
Page 55. Now, the complaint is being filed on behalf of numerous helpless and mute victims who have fallen prey to the alleged fraudulent and exploitative activities of an individual known as Raifuddin Ahmed. That is the petitioner, and his associates. The address is listed at so and so, He reportedly maintains an SBI account number so-and-so, which is also stated to be an ashram for Hindu devotees. The details of the alleged offences are as follows: cheating and financial exploitation. Gurudev and his associates are reportedly engaged in widespread financial exploitation, demanding exorbitant sums of money from devotees under various pretexts, including Harana to divine directly, Darshanwala Baba, and for pension in the guise of business investment. Fishermen, then something like it is Agarwell.
What is the
Victims-
date of your arrest?
That is 30th June. 28th June, 28th June. And Miller, police have also by now made the seizure. If your lordship will kindly come to page 62. That is, the details of seized articles are given in page 62, and it starts from 62, but the gist your lordship will find at page 63 and 64. The seized articles are nothing, in page 63, these are nothing other than the various documents which I have in my possession in respect of the licenses and other things that the government has granted to me. And page 64,
Why your prayer was rejected by the trial court?
Well, that is not very clear. Even in the forwarding report, Miller, they only say it is just a repetition of the statement.
Where is the rejection order?
Well, that order, your lordship will find at the last page, page 84. 82. Huh? 82. Second paragraph, Miller, from below. I am of the opinion that if the accused is released on bail, there are chances of threat to witnesses which may lead to hampering of investigation. Page 82.
We'll call for the case diary. We'll fix a short date.
Yes, lordship may call for the case diary. Only one thing I just want to highlight before your lordship. Your lordship will kindly see the forwarding report at page 57. The reason on which the state had registered my enlargement on bail, these are narrated in these lines. That if I am released, Miller, then I'll continue raising fund and I'll continue carrying activity. This is the only allegation. Now, the documents that they say that these are the implementing documents, Miller, they have already seized it. Your lordship will kindly come to page 57, that is the forwarding report, and reasons of arrest and detention, these are indicated in page 58.
We'll call for the case diary.
But as far as, Miller, the item number 27 is concerned, Miller,
We'll-
that is also out of the same FIR. The applicants are, Miller, my wife, son, and two cousins.
We'll go to that. Heard Mr. S. Datta, learned senior counsel, assisted by Mr. J. H. Soikia, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Considering the nature of accusation in the FIR, the perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. Yes, when?
Palma, Miller. Not very far.
Distance does not.
12, my lord.
12th. List this matter on 12th.
Or can it be, Miller, around 11?
Okay, 11.
Monday, 11. Just
11.
one day.
11. What is item number?
27 is also, Miller, from the same FIR, same facts, Miller. Only thing is that, Miller, although we are not named in the FIR, Miller, merely because we have a relationship with the accused, well, the police is after us.
We are calling for the case diary, giving interim, whether interim can be granted.
Where is the apprehension? You only
Why are you apprehending?
The accused number 4 in the, I am sorry, Miller, the petitioner number 4 in this case, Miller, he has a telephone connection from whose telephone, Miller, the accused had made certain calls. And that is the connection, Miller. If your lordship will kindly come to this paragraph, Miller, I have mentioned the reason.
And why others are
Others, my, the petitioner number 1 and 2 are my son and daughter. Wife and son. Merely because they are connected to me, my lord, by relationship, my lord, they are now being harassed. If your lordship will kindly see page 9, paragraph 11. And the phone number also, my lord, I have indicated there. Actually, this is the phone number the accused had used at certain points of time. Since the phone number belongs to the accused number 4, the petitioner number 4, my lord, he sought to be connected to the
heard
offense.
Mr. S. Datta, learned senior counsel for the petitioner, assisted by Mr. J. H. Soikia, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely number 1, 2, 3, 4, who are apprehending their arrest in connection with Mokalmoa PS case number 162/2025 under section 318/306/319/190/308 within bracket 5 of BNS, read with section 6 of Assam Healing within bracket Prevention of Evil Practices Act 2024. The gist of accusation in this case is that on 26 June 2025, one Rumi Thakuria, SI of police, had lodged an FIR before the officer in charge of Mokalmoa police station, inter alia, alleging that one Raifuddin Ahmed, who is the proprietor of Baba Shanti Composite Firm, has been indulging in cheating and financial exploitation of innocent person by taking recourse to psychological manipulation and fear mongering and claims of black magic for treating various ailments. Learned counsel for the petitioners learned senior counsel for the petitioners has submitted that the petitioners are not named in the FIR, and the main accusation in the FIR is against Raifuddin Ahmed. However, the petitioner number 1, 2, and 3 are related to the named accused, and therefore they are being harassed by the police. He also submits that the telephone of petitioner number 4 was used by the named accused, and therefore he is also being searched by the police in connection with this case. The learned senior counsel for the petitioner has submitted that the petitioners are ready to cooperate in the investigation. He therefore prays for allowing the petitioners to go on anticipatory bail. On the other hand, learned additional public prosecutor submits that
Though I don't, not in the FIR, but in the investigation, some materials may come against this process also.
submits that a connected case, in a connected case, case diary has been called and the next date is fixed on 11th of August. And he prays that in this case also case diary may be called for. Let the case diary be called for list fixing this matter on 11th of August. In the meanwhile, considering the submissions made by learned senior counsel as discussed in the foregoing paragraphs. The above named petitioners are directed to appear before the investigating officer of Mokalma PS case number 162/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop if they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2, list accordingly.
Item 51 from supplementary list.
For a TT application, Lordship. In this case, Lordship, petitioner was arrested on 8/6/2025. When he was arrested, the contraband was not recovered as per FIR. Lordship will find page, at page 15, the FIR Lordship, he was apprehended from his house at about 4:20, the second paragraph. Page number 15.
Yes.
May I read, Lordship?
No, what is the fact?
Fact is that, Lordship, at the time of apprehending me, no contraband was recovered. Then again, police visited my house. As per it is mentioned in the FIR also, that again they, in the second page, at page number 16, paragraph number 2, Lordship, they again visited my house. And then as per seizure list and the FIR, when I was not at home, from the backside of my house, 17 numbers of contraband recovered. That is the cough syrup bottle, Lordship. Then, Lordship, it is the allegation as per FIR. But, Lordship, what I calculate, when it's recovered, it is allegation. What I calculate as per this, Lordship, and this cough syrup are not the manufactured drug, as I found as per the CDO, Lordship, this notification. As per notification, Lordship, manufactured narcotic drugs, Lordship, serial number 35, at methyl morphine, commonly known as codeine, because they have stated these are the codeine-based cough syrup they have seized. So, Lordship, methyl morphine, commonly known as codeine, and early morphine and their salts, including thionine, all dilutions and preparation except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drugs per dose unit and a concentration of more than 2.5% in undivided preparation and which have been established in the therapeutic practice. If I calculate this 17, assuming it for time being, we considered it recovered from our position. In that case also, Lordship, it not be cross the beyond the limit, Lordship. I have calculated this, Lordship.
No, what is your submission? It does not contain codeine.
Codeine is even is in the bottles. In that case also, it will, if we calculate as per this, Lordship, it will be 0.2%.
No, we have to calculate the total.
Total quantity, Lordship. I have calculated.
No, how much each bottle contains?
As per the seizure list, Lordship, 100 ml.
100
bottle.
ml. So 1700.
Then, Lordship, we will calculate on this. We have converted to the percentage loss as per this notification, Lordship.
No, whether this is the way to calculate.
This is the way to calculate.
No.
Lordship, entire bottle we have considered. Entire bottle, 17 numbers of bottle with 100, Lordship. First, kindly see in the first thing, total 1700 ml.
We don't have to find out the percentage of codeine.
It is mentioned that, Lordship, 0.2%, which is within the permissible limit. So, if it is so, in that case, Lordship, I have also some authoritative judgment from division bench of Allahabad High Court, Lordship. it is not considered as a manufactured drug. If it is not manufactured drugs, in even harassing is also there from the apex code lordship, but harassing is regards to the contents entire bottle. We have considered entire bottle also in as per our calculation lordship. Even after that lordship, it is found in percentage as per this notification lordship, manufacture narcotic drugs notification 826 dated 14/11/1985 lordship, kindly see.
Now, what is the permissible limit of codeine?
Codeine is 2.5. As per act is lordship, 1 kg, 1 kg it's commercial good after 1 kg lordship.
Yes.
Then lordship, that is we have considered as per the judgment, we have seen all these things lordship, as per the judgment 2.5 if 100 ml bottle we have calculated.
Okay.
Calculated.
Then hearing is required.
Yes, lordship. Because it's
Let him also prepare. You are saying that it has to be calculated differently, not as per harassing.
not because this mentioned these judgments also lordship.
Okay, we'll consider those.
Because harassing in regards to the heroin, not the cough syrup bottle.
No,
We-
but it lays down the common principle, how to calculate.
Then as per this, we have to go by the notification lordship. I have seen one of lordship judgment also. In that case, that was beyond the limit. Beyond the limit, that is why lordship rejected that matter on that count. So lordship, I have calculated these 17 bottles, which is as per percentage lordship 0.2% lordship, which is not as per 2 beyond as per 2.5 as per this notification lordship. Codeine-based drugs are not the manufactured drug as per all the authoritative judgment lordship. I have found one judgment, Sahabuddin. Mohammed Sahabuddin, it was in bulk quantity. It is decided by the apex court in the year 2012.
It's simply saying, my lord, 17 bottles, 100 ml each, my lord. 10 bottles is equivalent to, my lord, 1000 ml is equivalent to 1000 gram, my lord, almost. And
My lord, kindly see that
17 bottles
calculation lordship. I'm
17 bottles is more than 1 kg. 1 kg is the, my lord, codeine is maximum, 1 kg is the, my lord, commercial quantity, my lord.
no, my lord, kindly see that calculation as per this notification. I'm not beyond the notification lordship. Kindly see the notification lordship. Volume must have to trace out lordship.
Where is that notification? You have
This one. lordship.
you annexed.
I am-
You annex that. You give a copy to the additional PP also. We'll
Lordship. This is the
it is pending investigation. We'll fix it.
pending investigation, but if lordship will not recovered from my position beyond the limit, then I am about 45 days behind the bar, lord.
No, this is not the notification. This is you have prepared outer.
This notification, lordship, it is mentioned in all the judgments passed by the honorable courts, lordship.
Now you produce the notification. Copy of the notification on which you are relying.
Calculation, regarding calculation, lordship. Which notification, lords?
Then not in commonly known as then not in some dimension. Now, whether it is more than 2.5% or less than 2. That can be ascertained only after FSL report.
Have calculated along with all the contents kindly, once kindly see lordship at the, my steps. If I'm wrong, wrong lordship may not consider my submission. Lordship kindly see the steps. Sorry, তোমাকে দিছি।
What is the content of codeine as per the label over the?
Their bottle, lordship, 1700
No,
milliliter.
what is the information provided over that bottle? 100 ml, how much codeine it contains?
Content 10 mg, it's 5 ml, 10 mg. It is mentioned in the seizure list, lordship.
It's 5 ml, 10 mg, but as per the harassing judgment, we have to count this
No,
100 ml.
we cannot live under this judgment because it is interpreted by the other courts, lordship. It is interpreted by the other courts.
Okay, we'll examine.
It is interpreted by the other courts, lordship.
What has been interpreted?
It has been interpreted in the judgment passed by the Allahabad High Court Division Bench in the year 2021, lordship. It is mentioned that these are not the manufactured drug. If these are not the
What are not?
codeine-based cough syrups are not the manufactured drug. These they have alleged that these are the codeine-based contraband cough syrup. So,
But the NDPS Act itself
no, lordship,
in the schedule provides that if it is codeine,
1 kg.
but lordship, interpretation is required. If codeine, then it's okay, lordship. But it is mentioned.
To be revealed from the official report.
No.
no, let us understand. Yes.
It is mentioned in the paragraph number 22.
Yes.
Paragraph number 22, lordship.
You produce this notification.
This notification I have placed right now.
No, you have placed the extract only, the exact notification on which.
It is mentioned here also. And on 14/11/1985, the government of India issued notification the number 826E dated 14/11/1985 and SO 40E dated 29/1/1993 containing the list of narcotic drugs and entry 35 thereof is as follows. This, whatever I placed before this honorable court, para number 30, serial number 35. This has been entered, lordship, methyl morphine, commonly known as codeine, and ethyl morphine and their salt, including thionine, all dilutions and the preparation except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drug per dose unit and with a concentration of not more than 2.5% in undivided preparation and which have been established in therapeutic practice. Then does as per
So this methyl morphine, if it is less than 2.5% in the entire preparation, no, not your calculation. If it is less than 2.5% in entire.
Yes, it is 0.2%.
On what basis you are saying?
Because chip see, kindly see that the bottle 1700
The bottles are of 100.
1700 ml. 100 ml.
No, 100 ml bottle.
See, it's 100 ml bottle.
100 ml bottle contains how much codeine?
It is while the entire bottle we considered.
How much codeine it contains?
Entire bottle. If entire bottle we considered, in that
No, you are not understanding my question.
each 5 ml content.
Apart from codeine, apart from methyl morphine, there are some other
other compositions.
composition, other ingredients. What is the percentage of codeine in the seized bottle in a per 100 ml? If it is more than 2.5%, then it is a manufactured drug. If it is less than 2.5%, then we can consider your submission.
Because that is why they have stated that harassing is applicable. If even harassing also applicable, if we consider entire bottle with the codeine, it is 1700 ml in 17 bottles.
No, you forget about 1700. You come to one bottle. How much?
500 ml contains 10 mg codeine.
500 ml bottle is not there.
5 ml, sorry. 5 ml.
If 5 ml contain 10 mg, how much?
That's not cheap in 100 ml.
5 ml.
In 100 ml, it will be 200 mg.
200 mg is
Not-
you calculate in the notification says that
2.
if it is less than 2.5%, only then you will be exempted. If it is more than, codeine is more than 2.5%, then it will be a manufactured drug. We'll call for the case diary and you furnish the notification so that he can also prepare. During hearing, we will consider. It is not a very clear case of bail at this stage. It needs consideration. If you succeed in persuading this court,
Some clear submission in this also. If it is correct, then this case will succeed, then lordship, some new law will be established by this court, lordship. That will-
let us see. Heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner submits that the quantity of contraband, the 17 bottles of cough syrups containing codeine, which was recovered from the house of the present petitioner, was recovered in his absence. She also submits that the said contraband does not contain prohibited quantity of codeine in pursuant to the notification issued by Government of India bearing number 826 within bracket E dated 14/11/1985 and SO 40 within bracket E dated 29/1/1993. He therefore submits that the contraband seized in this case would not come within the meaning of the manufactured drug under the NDPS Act, and therefore the petitioner is entitled to get paid. On the other hand, learned additional public prosecutor submits that the copy of the notification on which the petitioner is relying has not been furnished to him along with the, you received the bail application
Bail?
along with the bail application. And he submits that the contention raised by the petitioner needs a detailed hearing and also prays for calling of the case diary. Let the case diary be called for. No short date. You will take time. We don't have time now.
Yep.
25. 25/8. 26. Let the case diary be called for. The petitioner shall furnish the copy of notification on which she is relying to the learned additional public prosecutor. Within, when will you furnish? Within 2 days from the date of this order, list accordingly.
Let me
18 আগত খালি কি আছে 21
May it please, your lordship. My lord, in this matter, the sections which were labeled, my lord, maximum punishment is, my lord, up to 7 years. And my lord, this is a case where you also will find, my lord, that how FIR has been used as an instrument. FIR, my lord, may kindly see at page 13, your lordship.
What is the offense?
According to
Oxo.
mother of the victim, I have not done, I have tried to do something, your lordship. It's private part and all. In my shop at 9 p.m. In fact, at 9 p.m. my shop is closed.
Case diary would be required.
Before that, my lord, your lordship may call for case diary.
Yes.
Whether this is a case where, my lord, apparently I have, my lord, video and audio clipping also, my lord. His mother and the boy came to my shop on 4th of July for employment, your lordship. Since he was minor, so I have not allowed her mother to be in to engage him. Thereafter, my lord, they threaten us if I am not giving money, they will lodge FIR. And thereafter, after lodging of FIR, my lord, that your lordship will see page 27. His mother was calling me over phone and demanding money, page 27. Here, your lordship, Sunday 6 on the day when the FIR was lodged, these are the missed call. I was not aware whose number is this. Next day, 7th, 10 a.m. missed call, your lord. Call, she has given me call. 4 minutes 38 seconds. Thereafter, again incoming, 10 minutes 7 seconds.
These are missed call.
On 6th, these are call, and on 7th, this is the call. She made call asking for money so that she will compromise. And my lord, kindly see on law point also page 19, my lord. Prosecution himself, please. Prosecutor himself admitting that no notice under sections 41A was given. Page 20, your lordship will kindly see. And your lordship knows, my lord, in the case of Satendra until Honorable Apex Court held that. Last page, my lord.
Yes.
Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and magistrate do not authorize detention casually and mechanically. In order to ensure what we have observed ever, we give the following direction. All police officers be provided with checklist. Police officers shall forward the checklist. My lord,
Which para you are relying?
para 6, 11.6. Page 281, last page, my lord. 11.6. Notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police of the district for the regions to be recorded in writing. And thereafter, para 12, my lord, 1, 2. Para 11.7 also, my lord, failure to comply with direction aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. Thereafter, authorizing detention without recording regions as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. Thereafter, we hasten to add that the directions aforesaid shall not only apply to the cases under 498A IPC or section 4 of Dowy Prohibition Act, the case in hand, but also such cases where the offense is punishable with imprisonment for a term which may be less than 7 years. Well, this is important, my lord. Which may be extended to 7 years, whether with fine or not. Non-compliance, my lord, now your lordship may kindly come to Satyendra until decision. Para 100. Last page, my lord. And I am taking your lordship summary and conclusion. It starts, my lord, heading is summary and conclusion. Your lordship has got it, my lord. Page number 86. Last page, your lordship. Last two, first, before last page, my lord. Page 86. Summary and conclusion.
Yes, you come to the relevant portion directly.
100.3, your lordship. The court, your lordship has got it. The court.
There is no 100.3.
110 paragraph, my lord. In Satyendra until, my lord.
Page number?
Page number 86, para number 100. Heading is summary and
In
conclusion.
page 86, there is no para 100 in the,
I'm giving my copy, your lord.
in the
Must
copy.
be there, why? It is not there? I'm handing over 100.3, your lordship, may kindly. 100.3. $100.3, just
Page number 136. In your copy also it is 136.
from maybe
You are saying it wrongly.
I apologize. 130. 136. At the
Yes,
top, I was reading 86.
you
There are
are,
100.
you are more excited. Therefore, you are
excited.
not seeing pages properly.
My lord, I have, and at the top, it is 86. That's why that I have.
Yes.
At the top, it is 86. 100.3. The courts will have to satisfy themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail.
When 41A notice should be given?
My lord, if the punishment is, my lord, up to 7 years.
Suppose arrest is necessary, the investigating officer feels that though it is less than 7 years, but it is a case where arrest has to be made. What is the procedure?
See the notice, and if I am not complying with the notice, then he will arrest me. If the conditions I am not fulfilling as per the direction given by police officer, then he will arrest me.
Where is that in the Anish Kumar? Show me.
Arrest says, my lord, para 11. Para 11.
Yes.
Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily and magistrate do not authorize detention casually and mechanically. In order to ensure what we have observed ever, we give the following directions. 11.6, my lord, kindly see. Before that, my lord, all police officers provided the police officer forward or 11.4, my lord. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms of aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. The decision not to arrest an accused person will be forwarded to the magistrate within 2 weeks from the date of the institution of the case, with a copy to the
No,
magistrate.
that is not applicable.
Not
Here,
applicable. Thereafter, a notice of appearance in terms of section 41A CRPC be served on the accused within 2 weeks from the date of institution of the case.
where is the arrest memo?
Arrest memo, my lord, can you see? Forwarding,
Where is the forwarding?
page 19, my lord, 19. Only on the basis of apprehension I have been arrested. It is not that I have.
On 6 is the reason for. Yes, Mr. Das. Mr. Parashar.
My lord.
Otherwise, my lord, now POCSO.
And I am in judicial custody, my lord.
POCSO 8 and 12. So at this stage, my lord, yes, that can be, my lord, that argument can be made at the time of hearing, my lord, that let them notice be go, my lord. Can fix it out that without hearing the, my lord,
Where is the rejection order of the
My
trial?
lord. Because the matter of case is in, at the initial stage, it was rejected. Page, my lord, 21, 21. Really 25 days,
How many days?
25 days, my lord. Maximum period is 60 days, my lord.
informant is the mother of the victim, my lord, 14 years boy. So at this
He
stage,
used
my
to
lord,
call me and demanding money, my lord. That I have shown before your lordship.
that is telephonic call, my lord. There is no reason that the BCS demanded money.
Why the victim mother will be called?
What is your submission? The mother of the victim is entitled to participate in this proceeding.
Entitled, my lord, but they have not, before the London court below also, trial court, and my lord, only because of that, my lord, should I be behind the bar, my lord? Yes. Or your lordship may do, in Arnab Goswami case, my lord, what Apex Court has done, Apex Court has granted entering. So lordship grant me entering, and in the meantime, your lordship, let them come, and if my lord, your lordship found that, my lord, that I am not entitled, your lordship may recall that order. But this is the order passed by Honorable Apex Court for granting interim bail.
No, where in Anish Kumar you are showing that in every case,
My lord, in Satyendra until it was clarified.
no,
If Satyendra until said, if the 41A notice has not been given, which is
no, where, in which cases 41A notice is required?
if maximum punishment is 7 years. That Ernest Kumar says, para 12. Para 12 of of Ernest Kumar. 281 page. We hasten to add that direction aforesaid shall not only apply to the cases under section 498A IPC or section 4 of Dowy Prohibition Act, the case in hand, but also such cases where the offence is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine. Para 12, my lord.
No, but if the arresting authority can justify why notice was not given, if that justification is not
Based
there,
on- If the offence is, my punishment is below 7 years, my lord. If I am not
Sir.
complying with their notice, they are not saying anything. If had it been the case that notice was issued and I am not cooperating with the investigation, then I can understand, my lord. Going and apprehending person, 60-year-old person, because of someone FIR cannot be used as an instrument to, my lord, harass me, my lord.
no, that is not my query.
My lord.
My query is 41A notice
It's mandatory.
is mandatory if the arresting authority comes to a conclusion that arrest is not necessary. 41A itself says,
If arrest is not necessary, in that case, they will forward to magistrate. See why they are not arrested.
no.
But my lord, only see. The decision, element 1.5, the decision not to arrest an accused be forwarded to magistrate.
That is this, but what statutory provision is? 41A says where arrest is not necessary, notice will be issued. If the police can justify, and if that justification is found correct by the magistrate before whom he is produced, then in such cases,
there is not a single word about 41A by learned magistrate, my lord. In the order, your lordship will find there is not a whisper about 41A. Whether learned trial court has considered that aspect or not. They have written in their forwarding.
No, your submission is that 41A is not followed in this case.
My lord, and thereby I am entitled to bail as per Satyendra Antil.
This is to be considered. Your plea is to be considered.
This is my submission.
For that, we will require case diary.
Case diary, because my lord, 41A has not been given, it is.
Under, no,
admitted. It is admitted
my
by-
query is whether under all circumstances,
Apex code para 12,
what it says.
it says it is not only limited to 498A, it is
What 12 says? Read again.
we has them to add that the directions aforesaid shall not only apply to the.
What directions?
directions-
Where 41A notice is
Yes.
required?
No,
My query to you is different. My query to you is when 41A notice is to be issued in all offences under less than 7 years. If arrest is not,
Yes,
eh,
yes, my lord, it is written in the para 12 itself. It is not only limited to 498A, it is for other cases, but also such cases where the offence is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years,
yes,
whether with or without
yes,
fine. So it
yes.
covers everything, my lord.
yes.
It covers, my
The
lord.
main requisite of application of 41A is arrest is not necessary. So if the arresting authority can justify that though the offence is less than 7 years, but arrest is necessary.
Here,
When
but on
you
apprehension.
satisfy me
my
that
lord, kindly see the reason assigned by them, page 20, why they have not issued notice to me.
no reason is that you can influence the,
My lord, can, on the basis of presumption and assumption, my lord, nobody can,
that,
whether my history is this, or
That-
whether I have done something,
that,
whether
that,
I have-
whether reason is justified or not, for that, we have to consider the case diary. But my query to you is a legal query. Whether, is there any exception to 41? Is there any exception when for offences under 7 years, less than 7 years, 41A may not be issued?
that I have, my lord,
You answer this query.
I will examine, without examine. That is.
Heard.
Otherwise, my lord, Ernest Kumar and Satyendra Until has made clear that 41A is mandatory, and if it has not been followed,
But when 41, it says 41A is mandatory. But when 41A is to be issued, 41A itself clarifies under what circumstances.
interpretation, always an interpretation has been given by Honorable Apex Court in Ernest
40,
Kumar.
Anish Kumar does not say that in all conditions 40 notice has to be given.
Satyendra, until judgment, it ratify what the Ernest Kumar says.
You clarify that.
In Satyendra Until, it is specifically mentioned that if 41A has not been complied with, then accused is entitled for
But
bail.
41A itself says that it is to be issued only if when arrest is
That
not
is, my
necessary.
lord,
If there is an exception to that,
that in that case, clarification may be required from the court, my lord, in that case. My understanding is this, if the.
no,
offence is-
you assist this court.
What I understood, my lord, if offense is up to 7 years,
So in all
my
circumstances,
lord, this is my understanding.
irrespective of the fact that
If
the
this- if the
arresting authority
circumstances,
can,
if somebody is fleeing and my lord, they try to influence, in that case, I have to examine, my lord. But my understanding is if it is less than 7 years or up to 7 years, 41A is mandatory. If in compliance of 41A, I am not cooperating with the investigation, then my lord, police may arrest. This is my understanding till today.
we'll examine that.
Thought that, my lord, in that case, because
Yes, yes,
senior citizen, my lord, he is.
heard Mr.
he go
A.
ahead.
Goyal, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. learned counsel for the petitioner submits that in the instant case, the offenses which are involved in this case entails maximum punishment not more than 7 years. And therefore, there is a requirement of issuance of notice under section 35(3). 35(3).
3 BNS.
35(3) BNSS, which has not been followed in this case. On the other hand, learned additional public prosecutor submits that the offense involved in this case is under POCSO Act 2012, and therefore notice to the informant is to be issued before deciding the bail application. He also submits that in the forwarding report of the investigating officer while producing the petitioner before the learned magistrate after his arrest, the arresting authority has justified as to why 41A notice has not been issued in this case. On this, a query has been posed to the learned counsel for the petitioner by the court as to whether under all circumstances for offenses which entails maximum punishment of less than 7 years, it is mandatory to issue notice under section 35(3) of BNSS. And is there any exception to the said rule? Though learned counsel for the petitioner has cited the ruling of the apex court in the case of Arnesh Kumar versus State of Bihar and another reported in 2014, 8 SCC 273, as well as Satyendra Kumar until versus Central Bureau of Investigation, reported in 2022, 10 SCC 51. He prays for some time to answer to the query posed by this court. The prayer is allowed. In the meanwhile, let notice be issued to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within
2 days.
2 days from the date of this order, returnable on.
11, my lord, 11 others.
Will notice be served?
That's
You.
the required, my lord. No, it is not proper. It will go through PP, my lord, not PP.
11 per 11. List accordingly.
Deeply obliged.
Item 40.
Another problem. Pass over the matter for the time being.
Item 15.
Take to withdraw the petition.
Heard Mr. S. Muni, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Much obliged.
Item 16.
Yes, bail and offense under section 325, 35, 196, 1B of UNS and my lord 13(1) of the Assam Cattle Preservation Act. My lord, page 12 is the FIR. My lord, in this case, my lord, 4.5 kilogram of my lord suspected beef was seized, my lord. Page 12, my lord.
Who are you?
My lord, I am the proprietor of lordship
Hotel.
this hotel, my. I have the valid license, my lord, to deal with my lord. I have a next from page 14 onwards.
License to sell beef.
No, my lord. Buffalo meat, raw meat, chicken and dairy products. Now, my lord, on 1/7, the FIR was lodged, my lord. On 10/7, my shop was seized by the authority, my lord. Page 18, my. And the indication is that, my lord, I have this religious sentiment, my lord, this particular area, Algapur, my lord, dominated by befitting community, my lord. And my lord, as far as my knowledge goes, my lord, I am personally belong from that particular area, my. And lordship allegation, my lord, that they seized 4.5 kilogram and that has on suspicion, my lord, FIR was lodged, but subsequently, lordship page 18. This Sarimul Enterprise and the proprietor, my. As a seized, my, sealed by the authority.
Your shop has been sealed.
Sealed by,
Where is that order?
my lord, page 18.
Okay. Yes, let him appear. If his shop is sealed, if he does not appear, then arrest him. No, if he, you have to arrest him, therefore, only then you will be giving bail to him.
I mean, protected.
Yes. Heard. Mr. What is your name?
Jealous.
Heard Mr. J. Laskar Lanen, counsel for the petitioner. Also heard Mr. K. K. Das Lanen, additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ainul Haq Laskar, who has been apprehending his arrest in connection with Algapur PS case number 38/2025 under section 325 within bracket 3 325/3 within bracket 5 of BNS and section added section 196 within bracket 1 within bracket 6 of BNS. 190
196 1B.
1B of BNS read with section 13 within bracket 1 of Assam Cattle Preservation Act. The gist of accusation in this case is that on 1/7/2025, on an FIR was lodged by one Pradeep Kanti Purkayastha before the officer in charge of Algapur police station, inter alia, alleging that on receipt of an information through reliable sources that certain individuals are selling beef meat in violation of the provisions of Assam Cattle Preservation Act 2021. A search operation was conducted, and during search operation from the enterprise of the petitioner, namely Sharimul Enterprise, situated at Algapur Bazaar, 4.5 kgs of suspected beef meat was recovered. Learned counsel for the petitioner has submitted that the petitioner has a license to sell meat products, including buffalo meat, in his shop. He further submits that the suspected beef meat has already been recovered and his enterprise, that is Sarimul Enterprise, has also been sealed on 10/7/2025. He submits that the petitioner is ready to cooperate in investigation, and therefore he may be allowed to go on bail, anticipatory bail. On the other hand, learned additional public prosecutor prays for calling of the case diary. I have considered the submissions made by learned counsel for both sides. Since the suspected beef meat, which amount to 4.5 kg, has already been recovered and seized, and since the enterprise of the petitioner has also been sealed, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of Algapur PS case number 38/2025. So in view of above, the above named petitioner is allowed to go on bail of rupees. Is in view of above, the above named petitioner is directed to appear before the investigating officer of Algapur PS case number 38/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, as it is like 30,000 with one surety of like with following conditions, 1 and 2.
Item 17.
Disposed.
On the previous bail application, there is a close affair. The first paper, my lord, it was lodged by me. Lord, you will find page number 26. Also, may kindly come to page 26. This is our affair, my lord. Earlier in 2024, my lord, I lodged an affair against one Modilo Sarkar. And the allegation in that affair, my lord, page 26. বিনীত নিবেদন এই যে মোর নাবালিকা সোয়ালি সুমসুমা বেগম বয়স
Counsel for the petitioner also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Sirajul Haq, who is apprehending his arrest in connection with what is the PRC, what is the special POXO case number? If chargesheet has been laid, you have not given that number.
chargesheet number.
Not chargesheet number. You have received summons.
Yes, sir. I've given the sir, my lord.
No, in the cause title, you have to mention that number of this. What is the case number?
My lord, page number 20, my lord. Page number 20.
Special case number 90. This you have to mention in the cause title also, as per High Court rules. Special case number 99/2025, corresponding to Dowy PS case number 11/2025 under section 296/117 within bracket 2/65 within bracket 1/65/62/3 within bracket 5 of BNS, read with section 8 of the POXO Act. So learned counsel for the petitioner has submitted that on the basis of an FIR lodged by the mother of the victim girl on 4/1/2025, alleging that her daughter was assaulted and and daughter was assaulted and assaulted by the petitioner and his wife, and investigation was initiated and charge sheet has been laid against the petitioner under the aforesaid provision, penal provisions. Learned counsel for the petitioner submits that the FIR lodged by the informant is a false and concocted FIR lodged due to vengeance, as about how many months ago?
8 months, 15 days.
About 8 months ago, the petitioner had also lodged an FIR against the brother-in-law of the informant, alleging accusing him of committing offense under POCSO Act against his daughter. And in that case, FIR charge sheet has also been lodged against the brother-in-law of the informant, and he was not granted bail by the trial court. Learned counsel for the petitioner submits that though no ingredients of section 65 or any of the offences under POCSO Act is there in this case, which is apparent for from the perusal of the FIR, still police has wrongly filed the charge sheet against the said provisions, under the said provisions against the petitioner. Stop. Learned counsel for the petitioner has submitted that though the trial court has issued summons to the petitioner and fixed the next date of appearance on 1/8/2025. However, as the offense involved in this case are under POCSO Act, as one of the offense involved in this case is under POCSO Act, and under 65 cognizance is not taken.
Yes, but 65 cognizance is not taken, but also is there. Yes, 20.
Hence, he is apprehending that on his appearance before the trial court, he may not be granted bail. On the other hand, learned additional public prosecutor submits that there is no apprehension of getting arrested by the of the petitioner getting arrested in this case, as the trial court has only issued summons to him. Stop. I have considered the submissions made by learned counsel for both sides. And application under section 482 of BNSS is maintainable only if a person is apprehensive of getting arrested in connection with a non-bailable offense. In the instant case, after laying of the charge sheet, trial court has only issued summons to the petitioner, and the court which has issued summons is a court of Session Judge cum POCSO Judge Dowy, which is competent enough to consider any application for bail and even grant such bail if it thinks fit to do so under the facts and circumstances of the case. Hence, as there is no legal embargo on the court which issued summons to the petitioner to consider the application for bail and grant it if it thinks fit to do so. The apprehension of the petitioner getting arrested in the said case does not have any legal basis. Accordingly, this anticipatory bail application is disposed of with an observation that petitioner may approach before the trial court and may file regular bail application on his appearance before the said court, if so advised. Stop.
Item 18.
Highly.
Hotel lottery recovered 6.5 kg of beef meat, suspected to be beef meat lottery. The present person were arrested and this person is applied for the arrest.
Yes. Heard Mr. S. Munir Lanan. Here the 41 notice is not applicable because of 8 years punishment.
The other part of the has very large.
Heard Mr. S. Munir Lanan, additional public prosecutor, as well heard Mr. S. Munir Lanan, counsel for the petitioner. Also Mr. K.K. Das Lanan, additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Taleb Ali Sheikh, who is apprehending his arrest in connection with Jogi Gopa PS case number 79/2025 under section 299 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act. The gist of accusation in this case is that on 2/7/2025, on 1/7/2025, one Lal Baba Gwala had SI of police had lodged an FIR before the officer in charge of Jogi Gopa police station, inter alia, alleging that on receipt of an information regarding selling of beef in a hotel situated at Jogi Gopa Bazaar in contravention of the provisions of Assam Cattle Preservation Act, 2021, a search operation was conducted, and during such operation, 6.5 kgs of beef, suspected beef, was recovered from Nihal Hotel. And somebody was arrested? No. Nihal Hotel. So, who are you? And counsel for the petitioner submits that the petitioner is the owner of the said hotel and he is ready to cooperate in the investigation. He also submits that since the suspected beef meat has already been recovered, the necessity of any custodial interrogation of the petitioner may not be there. On the other hand, learned additional public prosecutor has prayed for calling of the case diary and has objected to grant of any interim protection at this stage. I have considered the submissions made by learned counsel for both sides. Since in this case, the suspected beef meat has been recovered and also seized, This court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid case. So, in view of above, the above named petitioner is directed to appear before the investigating officer of Jogi Gopa PS case number 79/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. This anticipatory bail application is accordingly disposed of.
Item 19.
Whatever lordship, truck was detected by the police lordship in Naka checking, carrying illegal timbers lordship without any documents or law lordship. Thereafter, my truck also seized. Lordship will kindly come to the FIR on page 9 lordship. Subsequently, this truck was seized by the police lordship. Initially, some other truck numbers is there in the FIR. So page 9 is the FIR.
In your truck, also some
That also lordship says that it was carrying timber without any document. The actual fact is something different, lordship. That lordship I am the registered owner, but on the last year on December of 24 lordship, I have already, though it cannot be done lordship, I have sold it to another person lordship. That agreement.
yes.
Lordship will kindly see.
Many documents are there, lordship, and moreover, forest acts are also there, lordship.
I am not
call for the city, lordship.
No, that definitely city may be
Documents
called for
are not
lordship.
there,
Let me complete my submission lordship. That page 20 lordship will kindly see. Though it cannot be done lordship, the vehicle was in a higher purchase lordship due to my hardship lordship, the monthly problem lordship. I have sold it out to one lordship, Sanidul Islam lordship. Kindly look at the agreement lordship. There is a notarized document lordship that mutual understanding lordship, the agreement has been done lordship. He have taken possession of the vehicle and he was paying the installment of the vehicle lordship. Though it was under higher purchase lordship, I cannot transfer it, I cannot sold it out also lordship as per the higher purchase agreement lordship. Though it is in higher purchase, so the Sanidul Islam name cannot be registered lordship. It cannot be transferred. So he was paying the installment monthly basis to the company, and vehicle was still in my name, lordship, registration name, but he was operating the vehicle.
Why are you apprehending?
Because the vehicle, the registration is in my name, lordship.
Okay.
That is why when the
But
vehicle
Mr.
number was charged, lordship, documents were found in my name.
Mr. S. Muni, learned counsel for the petitioner. Also, Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Taser Ali, who is apprehending his arrest in connection with Boshishta PS case number 145/2025 under section 61/303 within bracket 2 of BNS, read with section 24 slash, read with regulation 24 slash, no, section 24/41 of the Assam Forest Regulation Act. The gist of accusation in this case is that on 7/3/2025, one Boloram Kolita had lodged an FIR inter alia alleging that while conducting regular Naka checking duty at Jorabad Police Outpost. A truck bearing registration number AS28C9805 was stopped and it was found carrying timbers without any requisite documents. The said timbers were suspected to be smuggled timbers. What is your vehicle number?
That also will come to page 18 and 17, Lord.
Stop.
That FIR, this vehicle was named in the FIR, but subsequently my vehicle was seized. Lord.
Learned-
This is the
Learned
page
counsel,
17 and 18.
learned counsel for the petitioner has submitted that
And etc.
though the petitioner is no way involved in the offense alleged in the FIR. However, later on, his vehicle bearing registration number AS28C. What, this is your number?
Page 18, Annex 3 is the serial list of my vehicle. That has been seized in connection with this case.
His vehicle bearing registration number AS28C9935 was also seized in the said case, in connection with the said case, with an allegation of carrying illegal timber. Learned counsel for the petitioner has submitted that though the petitioner is the registered owner of the said vehicle and had purchased the said vehicle under hire purchase agreement. However, he had an agreement
Page 21.
with one Sanidul Islam, to whom he had handed over the said vehicle for use. It is also submitted that the said Sanidul Islam was paying the installment against the hire purchase agreement of installment of the said truck to the financer, and he was utilizing the vehicle when it was seized. In support of his submissions, learned counsel for the petitioner has submitted a copy of a deed of agreement for sale of vehicle as annexure 4 to the bail application. Learned counsel for the petitioner has also submitted that since the petitioner was not using the vehicle in illegal manner, and since he is ready to cooperate in the investigation, he may be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Let the case diary be called for. Let this case be listed on 27th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraph, the above named petitioner is directed to appear before the investigating officer of Bashishta PS case number 145/2025 within a period of 7 days from the date of this order, returnable 7 days of the date of this order. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Take conditions from Abhishek. list accordingly.
Can it be on 28 or 29?
28
28 or 20?
instead of 27, 28.
Much of that, much of.
Item 20.
That is at page 8. The allegation against the accused number of one lawsuit, basically the POXO Act is there. And I am the lawsuit, we are petitioner, brother, elder brother, and
Ready. And issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. Stop. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on when the case diary can be called. 14. Yes, through PP.
Item 51.
To my lord, DNS. You can see at page 15 FIR.
Yes.
My lord. The owner, my lord, he was going to, for the medical purpose, he was out of station, my lord, since long days, my lord. And manager was she arrested and police found 2.5 kg, 500 grams, my lord, suspected beef, my lord. Then it was seized, my lord. He was arrested and he was subsequently released by this one.
Heard Mr. J.U.N.M. Lascott, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Mohituddin Borbhuiya, who is apprehending his arrest in connection with Algapur PS case number 37/2025 under section 325/3 within bracket 5 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021 and added section 196(1)(b) within bracket 1 within bracket small b of BNS. Stop. The gist of accusation in this case is that on 1/7/2025, an FIR was lodged by one Pradeep Kanti Purkayastha before the officer in charge of Algapur police station, inter alia, alleging that on receipt of an information through reliable sources that some hotel are selling beef meat in contravention of the provisions of Assam Cattle Preservation Act 2021, a search operation was conducted and 2.5 kgs of beef meat was recovered from Ahmadiyya Hotel located at Alagpur Bazaar. Stop. Learned counsel for the petitioner has submitted that the petitioner is the proprietor of the said hotel and he was out of station when the said recovery was made. He further submits that as the suspected beef meat has already been seized and as the petitioner is ready to cooperate in investigation, he may be allowed to go on bail. On the other hand, learned additional public prosecutor opposing the grant of any interim protection at this stage. Prayed for calling for of the case diary. Stop. I have considered the submissions made by learned counsel for both sides. Since the suspected beef meat has already been seized in this case, and since the petitioner is ready to cooperate in the investigation, hence considering the nature of the offense involved in this case, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of Algapur PS case number 37/2025 within a period of 7 days from the date of this order and cooperate in the investigation, in the event he does so within the stipulated period of time, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions 1 and 2. This anticipatory bail application is accordingly disposed of. What is the submission? Heard Mr. C. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Das, call for the case diary. This is a charge sheeted case or investigation is going on. Call for the case diary and issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 21/8, list accordingly. AC to all combined.
At this distance, diary may be called for. Can be placed with
Mr. A. Parmanik, learned counsel for the petitioner. Also Mr. K.K. Parash, K.K. Das, learned additional public prosecutor. Boxer,
NDPS.
let the case diary be called for. List this matter on 19th August, 18th August.
Item 24.
Yes.
Okay. The petitioner here, there's some contractor. And say their ring ceremony has been solemn. There's a ring ceremony in between the petitioner and the informants. But their marriage has not been completed. Marriage has been completed, but thereafter some differences of mind has been arisen because uncle of the informant was employed by the petitioner in his business, and during that he missed about 10 lakhs amount from the petitioner.
What is the punishment under section 4 of
998. Now it's defined.
4 of Dowry Prohibition Act?
One 103 is there in my petition. 103.
85 will be applicable.
It is stated 103 lot. 103.
Yes, Mr.
Yeah, petitioner.
They have given a wrong petition.
103 is.
Section is.
Anticipatory bail application number 1811. What is who is the petitioner?
It is Federal Islam,
You have mentioned wrong provision, 85,
85 of BNS.
yes.
Earlier it was a 298.
It, and no, what is your What is your submission? He has given furnished.
Section was wrong. Wrongly
103
written.
is there. Lordship.
Because
My
the
bad.
section has been wrongly written, that's 103.
Okay,
Are you correct?
what is your submission? What is the punishment under section 4? 4 of Dowry Prohibition Act. You are not ready.
Okay, sir.
What is your submission?
My submission is, my lord, offense has not committed. He is not, our marriage has not been. completed.
85 may not be there. 85,
Yes.
but
And dowry, so dowry provision, my lord, question of dowry could not come because our marriage has not been solemnized at all, my lord. Only there is a ring ceremony.
no, but section 4 may come even before marriage.
Dowry provision, and the IO should have incurred them in those cases, I used to be incurred the matter properly, my lord. IO did not incur the matter properly. Your lordship kindly see page 17. I has stated that I have the honor to report that I have legally incurred the matter and found cognizance against the accused persons.
Now, why are we apprehending arrest?
Because now police, he said cognizance has been, they found cognizance against the page 17 loss of condition. That is why I have.
Section 4 is bailable or not? Section 4 of Dowry Prohibition Act. You know, you get prepared and we'll take it up after lunch. Whether section 4 of Dowry Prohibition Act is a bailable offense or not. Find out. And whether 85 is applicable to your case or not. We'll take it up
After lunch.
after lunch.
Item 25.
For it to apply. But to find out, page 18. Lord.
What is the offense?
The 51 of the Wildlife Protection Act, Lordship, and then 10 and 13 of the Arms Act. Lordship.
Case diary would be required.
Which are recovered in connection with some other cases, Lordship, as per the FIR, Lordship. Kindly have a look at the FIR, Lordship. Relevant person has, Lordship, then second period. Sure. And the next one, Lordship, that is as per the information, Lordship.
What is your name?
Sebastian Nursery, Lord. My name is Dear Lord.
Sebastian Nursery. You are accused number 1.
Yes. Lordship, that paragraph, as per the information, Lordship, these posters remaining inside the park for extending periods, accident during which they hunted elephants using the helmet SBML firearms. After killing the animals, they reportedly.
No, case diary would be required.
Another 2 accused, Lordship, they had approached before the Supreme Court, Lordship, by way of the bail application, Lordship. And this was the.
After perusal of the case diary.
Lordship.
Show me the.
At the page, there are 13, Lordship. 2 other accused could now name it.
Anush Nursery.
By the trial court also, Lord.
Ajit. Now, what is the submission?
Nothing is recovered from any of the accused of the present case, Lord.
some articles are recovered in connection with some other case, lordship, that is lordship, the Amgut case number 9 of 2025. It's reflected from the offer itself, lordship.
No, we will peruse the case diary.
Even to the learned trial court is also granted the interim protection to other, some two accused, lordship. That is reflected from the order, lordship. Paragraph 30.
No, we don't know what are the materials against you in the case diary. There may not be materials against co-accused, but there may be.
Lordship, it permits, it is pertinent to mention that one of the affair name accused Jordan Nursery lead to the recovery of a post-elephant carcass and bones in the Mainaguri region of the Amtika range of Swansea. The bone parts have been seized in connection with the Amguri case number 9 of 2025. It is reflected from the affair itself.
Yes, thereafter.
He also indicated that there are other elephants which have been posted in the Manos National Park and Amtika forest range and other parts of the reserve forest. The second part is also important, lordship. In view of the seriousness of the matter and the need to protect the endangered wildlife, I request that a case be registered.
Case diary would be required. Heard Mr. B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of accusation made in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. When? Let the case be listed again on 19th of August.
26 of the TV letter, that is the case number different, that is the case number 9 of 2020. I'm good at case. Same accusation.
No, what is your submission?
I'm not accused of the affair in that case. But I can 26.
26 also.
Sure.
In item 26 also case diary. Same date, 19. Same law, council, same order actually.
Not many accused.
We'll peruse the case diary.
Obliged.
Yes.
Here, section 4, the punishment is has been prescribed,
Is it bailable or non-bailable?
but in commentary I found it is non-billable.
It is?
It is non-billable
How?
because this act has been created so that the persons.
No, why it is non-bailable? Punishment is less than 3 years. So as per the
As far as
schedule,
it should be available,
then why it is non-bailable?
but non-billable, I found one commentary, just now I could not run through. It is reflected that although punishment is less, but it has been made non-billable.
But there must be some notification or the act itself somewhere must.
But act itself, it is nowhere mentioned whether billable or non-billable. It is nowhere mentioned, the acts.
Then in that commentary, on what basis in that commentary, there must be.
I have not found any basis.
Because apparently it appears that it should be bailable. If it is non-bailable, there must be some provision in the act itself.
There is no such act I quote. Section 4.
You need more time.
No, my lord, Lordship,
Yes,
I have not found.
let him appear. 498/85 does not appear to be applicable. Let him appear. Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, who is petitioner namely Shahidul Islam, who is apprehending his arrest in connection with Borpeta PS case number 257/2025 under section 85 of BNS, read with section 4 of the Dowry Prohibition Act. The gist of accusation in this case is that on on 4/6/2025, one Rahinur Siddiq had lodged an FIR, inter alia, alleging that she says that they enter into marriage.
Yes, they enter. It is, but fact is that ring ceremony is there. But thereafter,
That
they refuse to give the marriage.
He married the she married inter alia, alleging that the informant entered into marriage with the petitioner on 22/12/2024, and after the marriage, 20 days after the marriage, the petitioner demanded 15 lakhs rupees as dowry from the parents of the informant. It is also alleged in the FIR that the petitioner is now refusing to recognize the informant as his wife, and has subjected her to torture. Stop. Learned counsel for the petitioner submits that section 85 of BNS is not applicable to this case, as till date the petitioner had not married the informant, and only a ring ceremony was performed, and therefore there is no legal relationship of husband and wife between the petitioner and the informant. He also submits that the offense under section 4 entails punishment less than 3 years. Whereas offense section under 85 of BNS provides for punishment less than 7 years. And he is ready to cooperate in the investigation. Why are you apprehending?
Because police now is finding is that cognizance, uncognizance against the accused person.
However, the police is now searching for the petitioner, though whether notice was given under 35(3).
Notice given.
You have not appeared. Stop. Learned additional public prosecutor, on the other hand, praise for allowing, praise for calling of the case diary. We are disposing of this. I have considered the submissions made by learned counsel for both sides. Considering the nature of offense involved in this case, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of the aforesaid case. In view of above, he is directed to appear before the investigating officer of Borpeta PS case number 257/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2. This bail application is accordingly disposed of.
That is space 11 minutes. Delegation Miller 143 64 1 3 whole 5 JNSM 345 of the Immoral Trafficking Act. May I read that?
Yes.
With reference to
Who are you? What is your name?
my name is Hannan Ali Miller.
You are not named.
Here is Miller 2 Hannan Ali Miller. OMD Hannan Ali and Minor and 1 Hannan Ali Miller.
Hannan
Hannan Ali.
Alim.
Yes. In this case, the original owner is Monirul and the manager is one Sohida Khatun.
Owner of?
Monirul Ali. So it was conducted search parlor along with so-and-so Pokraza. During the raid, it was found that owner of Monirul Ali and 7 women were found at the spa parlor. During the search, some used and unused so were recovered inside the parlor and accordingly seized. During search, the Royal Spa Salon, 1 lady was found in so condition. Some mobile phones have been recovered from the parlor and also seized. It is relevant to, it will reveal that Miss Sohida Parvin is the manager of parlor. It is also revealed that one Hannan Ali Basugaon district is the prime owner of the parlor. Initially, Monirul is the owner, and secondly, Hannan Ali Basugaon is the Sirang also prime owner of the parlor. It is.
You are this Hannan Ali?
Yes, I am. It is found that MD Hannan Ali and Monirul, son of so-and-so, Ali Barbata, are running the parlor where so-and-so being carried out. Hannan Ali is absconding, that is the petitioner member. The parlor owner Monirul Ali.
Case diary would be required.
Some protection.
Mhm.
Some protection. Not in.
Yes,
He
Mr.
has himself.
Mr. Parashar. No. We are giving short date, but
But what happened in this case? The petitioner himself informed the police prior to that 2 or 3 days.
petitioner himself is?
He himself informed the police. I have categorically stated in paragraph.
Who are you? You are not the owner.
Yes, I am not the owner, my lord.
How you are related?
I am no way.
Why you have been named?
My lord, only on the basis of Monirul manner, whom the petitioner is a inimical relation.
We will call.
Also the prime parlor, that is the.
No, not in such case. We are giving short date.
I mean, it is not acted in this case of taking the petitioner. 345 of the Immoral Trafficking Act is the bailable offense.
And 143.
143 is the trafficking.
Not less than 7 years, my lord. There is put a no trafficking.
Why girls are involved?
That is, that part may be clarified by the Monirul, those who are arrested.
It will be clarified by the case diary.
Who is the-
Monirul and Shovita, they are the.
Who is the prime
corporate
active? Sovita may be the manager, Madam, but
entities.
as per the FIR, Madam, he is
Heard
also
Mr.
on
A. M.
the-
Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Considering the nature of accusation made in the FIR against the petitioner, perusal of the case diary would be necessary for consideration of the instant bail, anticipatory bail application, hence call for the same. List this matter when
Kukradar 11th. 11th.
11th.
Complex. Regular bail application, my lord. Offences under sections 21C and 29 of the NDPS Act. Sir, before your lordship goes to the record, my lord, may I give the brief facts of the case, my lord?
Yes.
658 grams of methamphetamine was seized, my lord, in 3 packets from 2 persons, my lord. Ataur Rahman and his mother Khudeja. Ataur Rahman and Khudeja Khatun's house, 658 grams of methamphetamine was seized. Now, based on their statement, 3 other persons get named, my lord. I, my wife Rumiza, and another person Zaki. Rumiza and Zaki, Ataur and Khudeja get arrested. Rumiza and Zakir also get arrested. Police does not manage to arrest me. On completion of investigation, police submit charge sheet, where other 4 persons remain arrested in custody and I am shown as an absconder. Subsequently, in the course of the trial, I was arrested in another case. So when I became aware of the pendency of the case, I voluntarily filed a petition in court that I am also an accused in this case. So production warrant was issued and I was produced before the court. And since 13/12/2024, I am in custody. Now charges have already been framed under 21C and 29 of the NDPS Act. There are 8 PWs, madam, out of which 2 PWs have already been examined now. And all the other 4 accused persons, they have been granted bail, madam. They have been by 2 by this honorable court, 2 by the trial. But they were granted bail only on the ground that grounds of arrest were not communicated to them. That would not be applicable in my case because I had voluntarily approached the court. So that part of the point for the other accused is not applicable in my case. Now, my entire case is based on this fact that I was implicated in this case based on the statements which were given by the 2 persons, Ataur Rahman and Khujeda Khatun, from whose possession this was found. And that your lordship will find, if your lordship kindly comes to page 16, my lord.
Yes.
May I read, my lord?
What is this?
It's the charge sheet, my lord. The relevant portion of the charge sheet.
Yes.
The brief facts of the charge sheet are such that on 8/8/2023, a written FIR was lodged by Mr. Ranjit Borgohai, son of so and so. Based on the FIR, Hujai Police Station registered case number 354 of 23 under sections 21C and 29 of the NDPS law. The investigation was entrusted to me and I conducted it accordingly. During the investigation, the informant was examined. After perusal of his FIR, I visited the place of occurrence. Evidence was found that indicated the illegal possession and selling of cocaine. At the time, it was cocaine, subsequently FSL gave a result for methamphetamine. Based on this evidence, 2 individuals, Mr. Ataur Rahman and Ms. Khudeja Khatun, were arrested and presented before the Honorable Court. The seized suspected cocaine was also presented before the court and following the court's directions was sent to the forensic laboratory at Kailipara for analysis. Further interrogation of the arrested accused, this is Ataur and Khudeja, revealed the involvement of 3 additional individuals in the drug trade, namely Rumiza Khatun. Rumiza Khatun is my wife, already granted bail. Zakir Hussain is another person, and Noor Ali, that is me, Rumiza Khatun was subsequently arrested and presented before the Honorable Court. It was also discovered that Zakir Hussain is currently in judicial custody in connection with another case. Therefore, showing him has been made before the Honorable Court. Noor Ali remains absconding despite efforts to apprehend him. His residence has been searched and a search list has been prepared. Upon testing the suspected cocaine, FSL report confirmed that the substance was methamphetamine. After informing the superior authorities about the status of the case on their instruction, charge sheet is submitted under so and so section. So my only submission is, if this case, if there is any other material other than the statements of the co-accused implicating me, my lord, in that case, the rigors of 37 will be applicable and I may not be entitled to.
No, what has been stated by those two accused against you?
Those two accused persons have implicated me along with Urmiza Khatun. And
How they have implicated? No, it is still, it is charge sheeted case. But you have been furnished with the copies of,
They have said that we are involved in the drug case.
how?
That is, my lord, as far as I've seen, my lord, their role has been, but additional beyond that, my lord, I don't.
Okay.
Regarding that part, latest report I have not yet verified, just I'll verify that.
Your submission is that apart from the statement of co-accused, there is nothing.
No other material.
You
However,
will,
the last Lordship felt the necessity to call for the case diary scan copy. That has
case
come.
there is there. You find out whether there is,
Otherwise, yes, at this stage, but trial has to go,
no, trial will continue. But he, if it is the only material, he may get bail. Let him go through. You find out, is there any other material apart from the statement of co-accused?
May I please, your lordship?
Yes.
Lordship 483 bail application, lordship, in connection with NDPS commercial quantity charge sheet case, lordship. NDPS case number 37 of 23, rising out of NCB crime 0623 under section 86, read with section 20B2C of N29 of NDPS. Lordship 310 kilo ganja was alleged to be recovered from the accused person in a truck, lordship. He is behind the bar since, lordship, 4/4/2023, lordship. He was forwarded to judicial custody 4/4/2023, lordship. And as of now, lordship, he is all total 849 days behind the bar. Lordship, the case is
2 years.
lordship 2 years, 3 months, 27 days, lordship.
How many witnesses are there?
Lordship, total 9, lordship. 6 are examined. Last witness examined, lordship, 24/3/2025. Since last 6 months, about 6 months, lordship. 5 months. And lordship, in this case, lordship, I am relying on the judgment of lordship Mohammed Muslim and Ravi Prakash, lordship. The
Yes.
fundamental right of the accused. I'm relying, lordship, the rights granted under Article 21 to the accused is override the statutory embargo of 37, lordship. Lordship, only 6 witness, lordship. Examined.
Oh, who are you? You are the driver of the truck.
Yes, lordship. Moreover, lordship, I have taken another ground, lordship. The grounds of arrest was not furnished to the accused. I have annexed the section 50 notice, lordship.
Section 50, what is your submission?
Section 50. Lordship, As per section 50 lordship, the grounds of arrest should be provided to the accused. And
No, but this arrest was before the judgment of Pankaj Bansal.
lordship, the constitutional provision was violated, lordship, Article 22(1). Because it is since amendment of since
If it is before Pankaj Bansal, then you have to show that you have communicated the grounds of arrest otherwise, orally or somehow. That endorsement has to be there, some material to show that you have otherwise communicated, not in the.
48, the 50A also violated, lordship. There is no 50A, lordship.
Okay.
My main ground is, lordship, the following incarceration.
Okay, heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Ms. M. Deka, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely, what is your name? Namely, Shri Jitender Kumar, who has been detained behind the bar since 4/4/2023, within bracket for more than 2 years, 3 months, in connection with NDPS case number 37/2023, corresponding to NCB crime number 6/2023, under section 20B to C/29 of the NDPS Act. The gist of accusation in this case is that the Narcotic Control Bureau had filed a complaint before the Court of Learned Special Judge. Which court?
Special Judge Amingaon, lordship. Kamrup Amingaon.
Special Judge Kamrup Amingaon, inter alia, alleging that on receipt of an information through reliable sources that the petitioner would be carrying huge quantity of ganja from Agartala to Bihar in a truck bearing registration number AS01 KC 6150, a search team was constituted and a Naka was arranged. During Naka checking, the aforesaid truck was intercepted. During search of the said truck, 310 kgs of suspected ganja was recovered from the said truck, and the petitioner was apprehended therefrom. Learned counsel for the petitioner has submitted that the petitioner is praying for bail in this case mainly on 2 grounds. Firstly, that he was not furnished with grounds of arrest. He was not communicated with the grounds of arrest at the time of his arrest, though notice under section 50 CRPC was furnished to him. It is submitted that said notice did not contain any ground of arrest therein. His second plea for his second ground for bail is that the petitioner has been languishing behind the bars for last more than 2 years, 3 months, and the trial has not yet culminated. Though 9 prosecution witnesses have been listed in the final complaint. However, only 6 have been examined. He further submits that the last witness to be examined by the prosecution side was on 24/3/2025, and since then, no prosecution witness has been examined. He also submits that in view of the observations made by the apex court in several of its rulings, the prolonged incarceration in such cases would override the embargo of section 37 of the NDPS Act. He relies, the learned counsel for the petitioner cited the ruling of the apex court in the case of Muhammad Muslim alias Hussain versus State within NCT of Delhi, reported in 2023 SCC Online SC 2353, as well as the case of Rabi Prakash versus State of Odisha, reported in 2023 SCC Online SC 1109, in support of his submission. On the other hand, learned counsel for NCB Ms. M. Deka has vehemently opposed the grant of bail to the petitioner on the ground that the quantity of contraband seized in this case is of commercial quantity, and the embargo of section 37 of the NDPS Act is applicable to this case. She submits that contraband in this case, which is of commercial quantity, was seized from conscious possession of the petitioner, and he was caught red-handed during the recovery and at the time of the seizure of the contraband. She also submits that the only 3 prosecution witnesses are left to be examined, and it would not take much time for examining the said witnesses, and therefore she opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of NDPS case number 37/2023. Code para 10, 11, 12, 13 from bail application 329/2023. And 10, 11, 12, 13. In the instant case also, the petitioner has been detained behind the bars for last 2 years, for last more than 2 years, 3 months, and the trial has not yet been culminated. Code 15. Code 16. In view of above discussion, the petitioner is found entitled to get bail on the ground of prolonged incarceration in this case. So, the plea of the learned counsel for the petitioner that grounds of arrest were not furnished to him in writing at the time of his arrest is not required to be considered, as the petitioner has already been found entitled to get bail on a different ground, as discussed herein before. Code 17, 2 lakhs with 2 sureties of like amount.
financially strong person.
There is only one accused person.
Only one.
310 kgs of ganja.
He is the only driver.
Okay, 1 lakh with 2 sureties.
Record.
Okay, learned counsel for NC. I'll correct it. To the satisfaction of which court?
Special judge.
Special Judge Kamrup. Amingaon.
Keep your bill.
Item 41.
Okay, please. What is the charge sheeted case, my lord? Registered under, my lord, section 103 of 106 64 BNS, and here, my lord, lordship will turn to page, my lord. Ten, my lord, the FIR. Small FIR.
Yes.
Respectful, humble request that about 2 years ago, the accused fell in love with my minor daughter so and seduced her to marry her. The accused kidnapped my minor daughter about 1 year ago and married her and kept in his own house. The accused beats my daughter from time to time and harass her in various ways. My daughter is 3-4 months pregnant. On 27/11/24, the accused forced my daughter to have an abortion and beat her to death. The body of my daughter is hanging to show the villagers. Here, my lord, the petitioner was arrested on 29/11/24 and the investigating agency, my lord, on 31/2, my lord, 24 had filed charge sheet, my lord, citing, my lord, 11 numbers of witnesses, out of which, my lord, 6 witnesses were already examined. 15. I have gone to the LCR, my lord, where, my lord, it say from the postmortem report, it says, my lord, it's a, my lord, hanging, my lord. As already the, my lord, the informant has, statement have been, the informant has been examined in the court, my lord. 6 witnesses has gone, my lord.
What is your ground?
I prepared my case, my lord, from outside the chairman.
Yes.
Page 35. This order dated 35/25, which will kindly come to paragraph number 7. 7 and 8 lordship. 7 lordship, the accused is facing trial under so and so. The prayer for bail moved on behalf of the accused was previously rejected by the order dated 21/2/25, 17/15.
Why POXO?
She was a
POXO is also there.
Fox is there, my lord, because according to the PM report, my lord, she was about 17 years of age at the time.
As per the date of birth also lordship, from the birth certificate also lordship, 25/2/2007, her date of birth. Then lordship, rejected by the order dated so and so. The evidence of the informant have been recorded.
Also, Mr. B. Sharma, learned additional public prosecutor. As well as Mr. D.K. Bhattacharya, learned amicus curiae, appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Jahidul Islam, who has been detained behind the bars since 29/11/2024, within bracket, for last 257 days.
45.
237. 245. 45 days in connection with special POXO case number 7/2025 under section 103. Charge was framed under section 103.
103 within bracket 1.
No, my lord, 108. Charge is framed under 108, that is suicide.
108.
is murder.
108.
108.
Under section
64.
108/64 BNS, read with section 6 of POXO Act, as well as section 9 of the Prohibition of Child Marriage Act. Stop. The gist of accusation in this case is that on 29/4/2024, the mother of the victim girl had lodged an FIR before the officer in charge of Olgosia Police Station, inter alia, alleging that about 2 years prior to the lodging of the FIR, the petitioner had kidnapped the minor daughter of the informant. And stop. It is also alleged that her daughter became pregnant, and on 27/4/2024, the minor daughter of the petitioner had an abortion, and the petitioner beat her to death. Learned counsel for the petitioner submits that the postmortem examination report of the victim girl shows that the death of the victim was due to what was your relationship with her? Oh yes, child marriage. Death of the victim who was married to him was due to suicidal hanging. He also submits that the petitioner has been detained behind the bars for last 245 days, and most of the material witnesses have been examined by the trial court. He submits that out of 11 listed prosecution witnesses, 6 witnesses, including the informant, have been examined. He also submits that the petitioner, unless petitioner is released on bail, he may not be able to defend his case properly. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that the witnesses who have been examined till date have implicated the petitioner in the offense alleged in this case. He also submits that though most of that 2 of the independent witnesses are yet to be examined, and the prayer for bail of the present petitioner was rejected by the trial court on 4 occasions, mainly on the ground that material witnesses were not examined by at that time. He also submits that there is a possibility of the petitioner influencing the independent witnesses if he is released on bail at this stage. Hence, he opposes the grant of bail to the petitioner. On the other hand, no, learned amicus curiae, Mr. D.K. Bhattacharya has also made submissions similar to that of learned additional public prosecutor and opposed the grant of bail to the petitioner at this stage. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of Special POCSO case number 7/2025. In this case, there are material to indicate that the victim was married to the petitioner, though she was minor at the time of her marriage. It also appears that the charges have been framed against the petitioner, inter alia, under section 108 of BNS. And the informant and most of the material witnesses have been examined. It also appears from the submissions made by learned additional public prosecutor that two of the witnesses were also examined in camera. The remaining witnesses, one of whom is a Caesar witness and another is a witness who deposed regarding the situation of the room where the dead body of the victim was found, are adult persons of 35 years of age and 52 years of age respectively. Though learned additional public prosecutor and learned amicus curiae have apprehended that both the independent witnesses may be influenced by the petitioner if he is released on bail at this stage. However, no basis for such apprehension, no material is there on record which could be the basis for such an apprehension. Hence, this court is of considered opinion that if sufficient conditions are imposed on the petitioner, the apprehension of learned additional public prosecutor as well as a learned amicus curiae may be addressed. Stop. Considering the fact that most of the material witnesses have been examined, as well as facts which are discussed in the foregoing paragraph, this court is of considered opinion that if the petitioner cooperates in the trial, his further custodial detention may not be necessary for fair completion of the trial of Special POCSO case number 4/7/2025. So in view of above, the petitioner and the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Special Judge POCSO Borpeta with following conditions, trial conditions. This bail application is accordingly disposed.
I'm applied, deeply applied.
Item 29.
You have gone through.
So they have put it. I have trademark.
Apart from that, heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Noor Ali, who has been detained behind the bars since 13/12/2024 in connection with special NDPS case number 2/2024 under section 21C/29 of the NDPS Act 1985. The gist of accusation in this case is that, where is the affair?
14 minutes.
Is that on 8/8/2023, one Ranjit Buragohai had lodged an FIR before the officer in charge of Ojai Police Station, inter alia, alleging that on receipt of an information that large quantity of suspected narcotics drugs have been kept in the house of the one Ataur Rahman, a search team was constituted and a search was conducted. During such operation, 658 grams of crystal-like powder suspected to be methamphetamine was seized therefrom, and the suspected accused, namely Ataur Rahman and Khodeja Khatun, were arrested. Learned counsel for the petitioner has submitted that nothing was seized from the possession of the present petitioner, and the petitioner, his wife, namely, where is the name?
Rumiza Khatun, madam, page 17. First line.
His wife Rumiza Khatun and one Zakir Hussain were arrested in this case mainly on the basis of the statement of the co-accused from whose possession the contraband was seized. Learned counsel for the petitioner submits that the petitioner was shown as an absconder in the charge sheet, and he himself informed the court while he was detained in connection with some other case regarding his name being there as an accused, and accordingly, on the basis of production warrant issued by the trial court, he was produced before the trial court. Learned counsel for the petitioner has submitted that in the meanwhile, all the co-accused have been granted bail on the ground that no grounds of arrest were furnished to them at the time of their arrest. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail mainly on the ground that apart from statement of the co-accused wherein he was implicated in this case, there is no material on which no material showing his complicity in this case. There is no other material indicated in the charge sheet which incriminate him in this case. Stop. He submits that in view of the judgments, in view of the observations made by the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2021 for SCC 1, the statement of the co-accused may not be admissible as evidence in a trial involving offense under NDPS Act. Stop. He submits that same may also be a sufficient ground on which he may be allowed to go on bail, as in absence of an admissible evidence, the embargo of Section 37 of the NDPS Act would not be applicable to this case. On the other hand, learned additional public prosecutor submits that the co-accused persons from whose possession the contraband was recovered have implicated the complicity of, have indicated the complicity of the present petitioner in the instant case. However, he fairly submits that apart from the statement of the co-accused, there is no other material in the records against the present petitioner. Considering the submissions, I have considered the submissions made by learned counsel for both sides and have gone through the records of scan copy of the records of special NDPS case number 2/H/2024. So, as in the instant case, apparently, apart from statement of the co-accused, there is no other material indicating the involvement of the petitioner in the offense alleged in this case. And as such statement is inadmissible in evidence in view of the observation made by Apex Court in the case of Tufan Singh versus State of Tamil Nadu within bracket Supra, the embargo of Section 37 of the NDPS Act is not applicable to this case. In view of above, the petitioner is entitled to get bail. Accordingly, the petitioner is allowed to go on bail of ₹50,000 with one surety of like amount, subject to the satisfaction of the learned Special Judge Hojai with following conditions. Trial condition 3. This bail application is accordingly disposed of.
Item 42. Petitioner, my friend, sister could not come today.
It is also not there.
And
Third, Mr. J. Ahmed
on behalf of
submitting on behalf of Ms. M. Das. M. Das prays for an adjournment on the ground of personal difficulty of the conducting counsel. Learned Mr. K.K. Parashar, learned additional public prosecutor, also prays for some time for producing the case diary. Prayer is allowed. Let this case be listed again on 19/8.
I please your lordship. The 483 application lordship.
Notices you took. Whether notice has been served. Heard Mr. S. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. Learned counsel for the learned additional public prosecutor, Mr. B. Sharma, has submitted that notices were issued to the victim, to the respondent number 2 long back. However, the service report has not yet been received. He prays for appointing an amicus curiae to defend the cause of the respondent number 2 in this case. This court, under the facts and circumstances of this case, is inclined to appoint an amicus curiae to defend the cause of this case. Accordingly, Ms. M.K. Brown is appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus curiae. The registry is directed to reflect the name of Ms. M.K. Brown as amicus curiae for respondent number 2 in the cause list henceforth. You furnish it today itself. When can we fix?
Fourth of July, lordship.
5th. Let this matter be listed on 5th of August.
34 and 35. Lordship, this one is behind the bar, lordship, 378 days. Okay. Total, witness my lord 23 witness, out of 23 my lord, 6 witness already examined. PW1 is the eyewitness my lord, informant, is already examined. And my lord, 47 and 48 my lord, in respect of item number 34. Grounds of arrest not furnished to the.
What is the date of your arrest?
Date of arrest, my lord, 18/7/2024. Arrest, my. Today is 378 days, my. Another ground, my lord. Another ground, my lord. Four against already granted bail, my. By this, my lord.
By
Not 25/7. But as per PW1, who is the eyewitness, my lord, informant, my lord. My lord, Bimol Rava gun fired to the Ashok Goel, my lord, present. Accused, my lord, prisoner sitting on the driver's seat of the Alto gun.
who are you?
Zahidul Islam.
Jahidul, and other case?
This is here for Bimol Rava and Rustum Rava, 2 persons before your lordship. They are also since 368 days, they are behind the bar. Total one of the witnesses 23.
What is your grounds of arrest?
Rest is the main ground, vital ground here, 47, 48. But it's not even sharp man. Delayed trial, Malad. And though the sheet is submitted, I am praying, Malad, the defense cannot be collected by the petitioner since he is in jail, Malad. So maybe provide the opportunity to face the open trial.
Regarding the grounds of arrest, so what has happened, Lordship, they were arrested on, Bimol Rava and Rustom Rava were arrested on 22/7/24. And Zahidul was arrested on 18/7.
No, let us take the case of us,
Yes,
Jahidul Islam.
right, yes, Zahidul was arrested on 18/7/24. Lordship, in that record, Lordship, I went through, there is no order or anything regarding his arrest also. Even the forwarding is also not in the records. I tried searching for the arrest memo.
But notice has been produced.
That itself is not in the record. I could not verify that.
You can verify from this.
Look, I've gone to the records, so it is not in the records. That's not something.
So scan copy has not been properly.
Yes. that is what happened. And regarding the other two accused also, Lordship, nothing is there. Even the date of arrest, on that day, they were produced, that is also not in the case, record.
We'll call for the. What is your submission?
Up to date.
That has to be verified.
Even Lordship, they can also verify, Lordship.
You can produce the notice which you were served.
In my case, it was not served.
Then we have to verify. In your case, you have the certified copies. You have the photocopies of section 47 notice. Yes or no? So say yes.
Similar footing, perhaps in one
No.
case.
No, but in your case, there is no material. Without verifying. Okay, heard. In item number 34. Item number 34. Heard Mr. Z. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned this application under section 483 of BNSS has been filed by the petitioner, namely Jahidul Islam, who has been detained behind the bars for since 18/7/2024 for last 378 days in connection with Sessions case number 127/2024 arising out of Agya PS case number 64/2024 under section 126 within bracket 2, 310 within bracket 3 of BNS, read with section 25 within bracket 1 dash capital A bracket close /27 of the Arms Act, which is pending before the Court of Learned Additional Session Judge, Goalpara. The gist of accusation, Court Para 4 from bail application number 2089, which is in the record. Here per logo. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since for last 317 days, 78 days. And in the meanwhile, one of the co-accused, how many have been released? one of the co-accused, namely Abhijit Basumatari, has already been released on bail. He further submits that petitioner is seeking bail mainly on the ground that at the time of his arrest, the notice which was served on the petitioner under section 47 of BNSS does not contain any ground of arrest therein. In support of his submission, learned counsel for the petitioner has furnished a copy of the notice issued to him under section 47 of the BNS. Learned counsel for the learned additional public prosecutor, on the other hand, has submitted that on perusal of the scanned copy of the records, he could not find any notice under section 47 issued to the petitioner there in the said record. However, on perusal of the copy of notice produced by learned counsel for the petitioner, he fairly submits. You have seen the notice? Yes. You have to give a copy of notice to one copy, then we'll fix a date for furnishing. That you have to do beforehand. You see, show him the notice. Fairly submits that the said notice does not contain any grounds of arrest apart from mentioning the police station case number and penal provisions involved in this case. Stop. Furnishing grounds of arrest. Though the petitioner has furnishing grounds of arrest, though the petitioner has been languishing behind the bars for the last 378 days. However, it appears that he was not communicated the grounds of arrest, in writing, at the time of his arrest, which is a mandatory constitutional requirement under Article 22 within bracket 1 of the Constitution of India. Violation of the said fundamental right would would vitiate the arrest of the petitioner, and on that ground itself he is entitled to get bail. Stop. For the aforesaid reasons, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned additional session judge Gwalpara with following conditions. Conditions same as A2 case of JK. And in 34, what is to be done in this case?
Same Lordship, I could not find any notice or anything. Even their date of arrest, whether they were produced or anything, nothing is there.
Okay.
On that day.
Heard Mr. Ainuddin, learned counsel for the petitioner. Petitioners, two petitioners are there. Petitioners. Also heard Mr. B. Sharma, learned counsel, learned additional public prosecutor. Learned counsel for the petitioners has submitted that the petitioners are seeking bail mainly on the ground of prolonged incarceration, as both the petitioners are behind the bars for last 368 days. 68 days. When were you arrested?
Arrested on 29/7/2024.
Is there anything to indicate?
Yes, ma'am. I have raised the forwarding report.
Forwarding report is there.
It's not in the report.
It, if notices were given. No, let us give a date. 160 days. He has also submitted that the petitioners are also seeking bail on the ground that no notice, no grounds of arrest were communicated to them when they were arrested and as such, their fundamental rights guaranteed under Article 22 within bracket 1 of the Constitution of India has been violated in this case. On the other hand, learned additional public prosecutor has submitted that the scanned copy of the records, which is available with the court, does not indicate as to on which date the petitioner were arrested, as the even the forwarding report of the petitioners is not present therein. He also submits that no notice under section 47 of the BNSS issued to the petitioner is there in the records, in the scanned copy of the records. Stop. It appears that while sending the scanned copy, the trial court has not sent all the documents which are relevant to this case. The trial court, that is the Court of Learned Additional District Judge, is therefore directed to submit a report as to whether the notice under section 47 of BNSS, whether copy of notice under section 47 of BNSS issued to the petitioners, namely Shri Bimal Rabha and Shri Rustam Rabha, are available in the records of the Sessions Court, Sessions Case number 127, 2024. Stop. If it is available, a copy of the same shall be sent to this court so as to reach this court latest by 7th. 7th of August. Least accordingly.
Item 46.
36 versus,
To dispose
taken
on
up
it.
after some time. It is available after some time also. JK Das has gone to the case like that. Please come there.
Let him come.
37.
May please your lordship, the intermediate quantity lordship, the 21B, 29 lordship.
How much?
2 days behind the bar lordship,
what is the contraband?
Contraband lordship, 10.45. 45 gram.
11.75 net weight.
With container.
Net weight.
Of heroin?
Yes, suspected.
11.75.
I am the driver lordship, my vehicle is held by some passenger in from ISBT Guwahati to Lalok. Said
How many days you are behind the bars?
48 days.
What is your submission? That it is not from whose possession it was,
The said bag is recovered from my vehicle in the backside.
whose bag is it? It was.
The passenger's bag. At the touring travel lordship, my vehicle was held by from the ISBT.
Yes, Mr. Sharma.
Lordship, the earlier rejection of that is at page 19, Lordship. Learned Court Special Judge NDPS has rejected the bail application at page 19, Lordship. 23,625. If Lordship kindly takes up page 19, paragraph number 6. Paragraph number 6, Lordship. 7 goes on to say, Lordship, that the total quantity 11.75 grams, intermediate quantity of paragraph 7. And Lordship, the paragraph number 12 and 13.
What is your name?
Islam Ali. Lordship.
So in paragraph 7, it is mentioned that 30.65 gram.
11.75 grams,
With container.
actual quantity, net weight. Net weight. Now, Lordship will kindly come to paragraph 13 for a moment, Lordship.
Yes.
It further appears from the case record that the co-accused are still absconding and the police are trying to apprehend them. Considering that it was at a nascent stage, the bail application was rejected. Even now, Lordship, the co-accused has not yet been arrested and FSL report is still awaited, Lordship. That is the progress of the case.
Who is the co-accused?
He has named some person, Lordship, from whom.
The had the vehicle lordship. He's played away from the checkpoint. The bag is left in the middle portion of the backside seat. This car. Lordship, the length of detention as the lordship, the 48 notes are closed.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Muhammad Islam Ali. Oh, no, how it was found that they were co-accused?
FIR itself, Lordship, will see.
There is an indication that somebody fled away.
Yes.
Okay.
Following.
No, in FIR there is no indication.
His statement, Lordship, he has stated there are more persons involved. That is why, Lordship.
Legally. last line. Who has been detained behind the bars since 13/6/2025 within brackets for last 48 days in connection with Vipuria PS case number 124/2025 under section 21B/29 of the NDPS Act. Stop. The gist of accusation in this case is that on on 13 on 14/6/2025, one Jogokanto Gogoi had lodged an FIR before the officer in charge of Vipuria police station, inter alia, alleging that during the course of regular Naka checking at Vipuria traffic point, the petitioner was found in petitioner was found in possession of 30.65 grams of suspected heroin, including the containers, which were kept in the vehicle in which he was traveling. Stop. Learned counsel for the petitioner has submitted that the petitioner is a driver and the vehicle was hired by some other persons who fled away at the Naka checking point, and the bag from where the contraband was recovered and the bag from which the contraband was recovered belonged to the said accused persons. He submits that the petitioner has been detained behind the bars for last 48 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of the Vipuria PS case number 124/2025 and has submitted that though the investigation has fairly progressed, however, co-accused persons who were implicated by the petitioner in his statement are yet to be apprehended. He also submits that the FSL report has also not yet been received. I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by the learned additional public prosecutor. Considering the progress of the investigation and the period of detention undergone by the petitioner, this court is of opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of aforesaid case. Accordingly, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned Special Judge Lakhimpur, not Lakhimpur, with following conditions. Send back the case diary. This bail application is accordingly disposed of.
Okay. Here in this case, my lord, the petition is in custody is in 27 December 2024.
27.
7,
What is the offense?
my lord,
Charge sheet has,
section-
charge sheet has been laid. You appear before the trial court. Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. K.K. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the charge sheet was called, though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
64/25 dated
My
20
lord,
February
here in this
25.
case, my lord, the bail petition was rejected on 5/4/2025.
during investigation. Now,
I think it's after charge sheet. My lord.
by whom?
My lord, the special judge.
After filing of charge sheet. When the charge sheet has been laid,
28th of February. They have filed this application in the month of July,
after filing of charge sheet.
but they have not paid for calling of the scan copy also or anything like that. They have not mentioned that it is.
Oh, nay. What is your ground?
My ground is that the learned court rejected the bail, saying that the remand period is 90. So charge sheet he is not entitled to default bail. But when the section, allegation is a section under, offense under section 8 of the act, but it was, the penetration was not there. So there cannot be said that it was a rap, my lord. The offense may be, my lord, punishable under
Now,
5 years.
now,
So.
will you
default bail was
go,
untitled.
no, will you go and pray before the trial court, or should we call for the scanned copy of the case diary? Because we don't have any material now, unless we peruse.
Since, as for the pleading, my lord, bail has been rejected after the charge sheet, my lord. Whether it will be.
Yes, yes.
goes below.
After charge. After charge sheet, you prayed for default bail.
Charge sheet, my lord, charge sheet was submitted on 89 days. And the pleading is that it was not
Miss-
punishable of that extent, my lord.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Mr. B. Sharma. Let the scanned copy of the trial court record as well as case diary be called for. It also appears from notice, office note dated 29/7/2025, that service report has not been received in respect of respondent number 2. Stop. London additional public prosecutor is requested to take the information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date. Let this case be listed on 22nd August.
Develop. Lab vigilance. Earlier date, my lord, up to date, record of call for is not received. Up to the status. And a few vital witness not yet examined, my lord, because of that, my lord.
Also,
No, my lord. 302 is there, one small boy was killed, my lord, murdered.
Lordship, the accused was Lordship arrested and forwarded on 10/8/2023, Lordship.
no, but the offense is also grave,
Lordship,
and the report was called for. Whether that report has been received. Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. the report which was called for from the trial court by order dated 17/7/25 has not yet been received. Registry to issue reminder for the same. Let this case be listed again on.
This case, Lordship, I had taken plea of the ground secretaries, Lordship. I have annexed the notices mentioned, Lordship. On earlier date, I have submitted before the Lordship, but Lordship stated the Lordship.
No, but not without perusing the report.
Lordship, out of 39, Lordship, on last occasion, Lordship, 21/7/2025, Lordship.
What is the date of your arrest?
Date of arrest, Lordship, 9/8/2023. Since Lordship, already Lordship, I am behind the bar since 721 days, Lordship, 1 year, 11 months, 21 days. Lordship, listed.
9/8/2023.
statement
What is the date of judgment of Bansal?
is prior, Lordship, one month prior to Bansal.
You find out, is there any material which indicates that scan copy of case diary is there? You find out. Till then, we'll await for the report which was called for. ये लिखे ले last line. 21st of August.
The next date before the trial court is Lordship for production, Lordship, 4/8/2025. And for evidence, Lordship, 1/9/2025.
Let it be after that date.
Lordship, 4/8/2025.
1/9.
No, Lordship, kindly, Lordship. Because
Then let it be 21st of August.
My pleasure, Lordship. Earlier occasion, your Lordship, 2 times. PCR was called for, but as per office note, he had not received. But in this case, matter relates to POXO matter. But he was arrested on your Lordship's 21/11/2024. As on today, your Lordship, 253 days behind the bar.
With a notice served on the.
As per that. So, but as per search sheet has been laid down, 9 witnesses here. Not to disturb. 2 occasion, your Lordship, from Kamrup Metro, special judge. So, he is old aged person. And 4 witness has already been examined. Perhaps your Lordships, other witness
Criminal appeal or superintendent court.
as examined.
Robert of Matibabu, Kamrup Metro, phone recorder. Heard Mr. S. Islam, learned counsel for the petitioner.
Page number 2, post title party, your Lordships. Session special case number 36/2024, this petition, but wrongly typing mistake in the year part. That ought to be 2025.
You file a amended cost item.
Yes.
On perusal of the office note dated 30/7/2025, it appears that the scanned copy of the records of the trial court have not yet been received. Issue reminder for the same. Registry to issue the reminder. It also appears that the notice issued to respondent number 2 also has not been
They have taken step 2 times.
served. Learned additional public prosecutor is requested to get information regarding the fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Stop. Learned counsel for the petitioner has submitted that due to inadvertent typographical mistake, some mistake has crept in the cause title of the bail application and hence prays for filing an amended cause title. In this case, the prayer is allowed. Let this case be listed on 8th of August. No, not possible. 8th of August.
I have taken step as well as.
Wait till 8th.
Remainder also, but not yet received. So ultimately 253 days behind the bar, 4 witnesses has already been examined. Victim as well as informant as his victim.
Wait till 8th.
Of like 55.
55, 57, and 58 are same.
Oh, it is, yes, yeah.
57 and 58 are the same.
55?
57 and 58. I am for 58.
Yes, 55.
We have received the communication from the IO lordship. Due to the ongoing law and order situation in Gwalior lordship, the IO could not send that PG lordship. So let me pick in the next week also introduce the case.
What is the offense? What happened in Golpara? Sir. Okay.
Where's the third page?
Lordship, we have submitted the certified copy of notice of under section 47 Lordship.
It is NDPS case.
If you consider the certified copy,
No, because under section 52 of the NDPS Act, apart from 47, some other document may also be given to you, mentioning the grounds of arrest in that document. Suppose in 47, 48 grounds, 47 grounds of arrest is not mentioned, but prosecution side gives a notice under 52 mentioning grounds of arrest therein, then it may be compliance. Therefore, perusal of the case diary would be necessary.
section 50 and inspection report is with me.
50 is different.
Memo, your lordship, certified, I have not any.
That will not help. You have to wait till the case diary comes.
A short time, hard time to receive. Tuesday lordship is 162 days.
Else I leave it to your lordship.
How much is contraband?
6 corpora property. From very clear.
Heard Unkil's name likhibo tinota. Mr. R.A. Chaudhary in item number 50, 55. Mr. S.H. Rahman in item number 57. And Mr. S. Islam in item number 58. Also Mr. B. Sharma, learned counsel for the learned additional public prosecutor, who submits that the investigating officer of this case, investigating officer has informed him that due to ongoing law and order problem in Gwalior district, the petitioner could not send the case diary. That is not a very valid reason. Whatever may be the problem, when court calls for some document, you have to send it. Though I am allowing. He has prayed, learned additional public prosecutor has prayed for some more time to produce the case diary. The prayer is allowed. When will you produce? 8th. No, 8th is the shortest day stay available.
7.
No, okay, 7. Let this case be listed on 7.
Lordship, it's a application under
Is a notice not lordship. The scan copy was called for and also the notice was issued lordship.
Notice has not been served.
No, sir, so it was taken very recently probably lordship.
But you have not taken steps for issuance of notice. Okay. What is your name?
So probably the scan copy also probably has not been issued.
Okay. Heard Ms. N. Deka, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner could not take steps for issuance of notice upon respondent number 2 due to some difficulty and seeks some more time to do so. The prayer is allowed. The petitioner shall take steps within 3 days from the date of this order, returnable on 21/8. The scan copy of the trial court records have also not been received. Issue reminder for the same. Registry to issue reminder. List accordingly.
Timing item 14.
Yes.
Matter pertains to my lord charge sheet, which has been filed under section my lord 11 of the Cattle Act matter.
Charge sheeted case. Why?
Petitioner is the owner of the vehicle.
Now, why are you seeking anticipatory bail?
Trial,
Normally would not do.
they are reluctant to grant bail in these cases because these cases are exclusively triable by the sessions court.
I will clarify that in the order.
The Prahlad Bhakti judgment is there.
What judgment?
Prahlad Bhakti judgment.
What it says?
It says that my lord, normally it is preferable that the magistrates in sessions tribal offences, instead of granting bail, should refer the same to the court of sessions. That judgment-
Irrespective of punishment.
Yes, that judgment I can place, my lord, that it says that, my lord, even though there is no legal bar for a magistrate to consider an application for grant of bail to a person who is arrested for an offence exclusively triable by a court of sessions, yet it would be proper and appropriate that in such a case, the magistrate directs the accused person to approach the court of sessions for the purpose of getting the relief of bail. It's an old judgment, my lord, 2001 judgment. That is why, my lord, sometimes the magistrates they rely on the judgments and refuses to grant bail. Otherwise, my lord, there is no apprehension because it's a 8 years punishable up to 8 years.
Yes, Mr. Sharma. I will clarify that. What case was involved in that case? Bhatti's case?
This was, my lord, case of 306 and 498A.
306.
498.
306. What punishment is there?
Punishment was perhaps life.
306 attempt to murder. Abatement of suicide. Verify. I'll clarify it now.
Punished with imprisonment for up to 10 years and also liable to fine.
Also,
Liable to fine. This is when a Cattle Act.
yes,
It's 8 years.
yes. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Ubaidul Haq, who is apprehending his arrest in connection with PRC case number 301/2025 under section 303 (2) 317 within bracket 2/317 within bracket 4 of BNS, read with section 11 within bracket 1 within bracket A, small a within bracket small b within bracket small d, and within bracket small c and within bracket small c and small d of Prevention of Cruelty to Animals Act, as well as section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 4/2/2024, no, the gist on 4/2/2022, 4/2/2025, one Indira Brahma had lodged an FIR before an officer in charge of Rupohiat police station, inter alia, alleging that an information was received that one vehicle along with some cattle as well as one cow lifter was apprehended by the villagers of Rupohi within bracket Bilpar village. Accordingly, the police reached there and apprehended the accused petitioner, namely Anwar, no, apprehended the accused Anwar Hussain from there and also seized the vehicle bearing registration number AS01SC 5393. Stop. Learned counsel for the petitioner has submitted that they, after the filing of the said FIR, investigation was initiated and ultimately charge sheet was laid before the court of learned Chief Judicial Magistrate Nagaon. He submits that you have received summons.
Yes.
What is the date of appearance?
I'll verify it.
And the petition, though the petitioner has received summons from the trial court, however, he apprehends that as the offense under section 13 within bracket 1 of the Assam Cattle Preservation Act is tribal exclusively by the Court of Session, the Court of Learned Chief Judicial Magistrate may not grant bail to the said court, to the accused. In light of the observations of the apex court in the case of Prahlad Singh Bhatti versus NCT of Delhi. What is the Supreme Court citation? Reported in Indian Kanun citation here, Pradidip. Wherein it has been observed that, where is that observation?
My lord, in page number 3, my lord, second paragraph. Even though
wherein there is an observation of the apex court that even though there is no legal bar for a magistrate to consider an application for grant of bail to a person who is arrested for an offense exclusively tribal by court of session, yet it would be proper and appropriate that in such a case, the magistrate direct the accused persons to approach the court of session for the purpose of getting relief of bail. Stop. The observation of the apex court was made by the apex court, was made in a case which involved offense under section 302/406 and 498A of IPC. And therefore, 302 is involved.
Yes, 302.
Therefore, the said observation of the apex court should be read as to be applicable in only cases of nature, cases of those nature in context of which the said observation was made. However, in the instant case, there is no, however, Katidio, it is also important to note that in an offense under section 302, there was also an embargo under section 437 within bracket 1 within bracket 1 CRPC new to grant bail
Four 37,
437
37, 1.
1 within bracket small Roman 1 to grant bail in offenses which entails punishment of life imprisonment or death penalty, as was prescribed under section 302 of the Indian Penal Code. Stop. However, in the instant case, the offense involved in this case is under section 13(1) within bracket 1 of the Assam Cattle Preservation Act, and the punishment prescribed for the said offense is maximum punishment prescribed for the said offense is up to 8 years only, and no embargo is there on the Court of Learned Chief Judicial Magistrate to consider an application for bail and also to grant bail if it thinks fit to do so under the facts and circumstances of a particular case. And therefore, this court is of considered opinion that the apprehension that the Court of Learned Chief Judicial Magistrate Nagaon may not grant bail to the petitioner if he appears before the said court in pursuant to the notices received by him does not have any legal basis. This anticipatory bail application is accordingly disposed of with an observation that the petitioner may approach the may appear before the trial court and may pray for regular bail before the said court, if so advised.
Next date is on 8/10/2020.
8
8 of October.
may appear before the trial court on the next date fixed. Next date fixed in the PRC case number 301/2025. That is 8/10/2025, and may pray for
SCC 280.
प्रहलाद सिंह और जी इंडियन कानून और साइटेशन और जगह 2001
SCC
और SCC 280.
highly.
Very good. This is application when I think under 483, my lord, he was arrested. Actually, though he was arrested on 10/6/2025, my lord. Actually, he was arrested long back in 2018, my lord. 19, my lord. May 19, my lord, in case of a home blast case, my lord. And he was released on bail, my lord, on 9/6, my lord, by the near court, my lord. That you will also find at
When he was arrested,
and he was on 10/6, my lord. Initially, he was arrested by the near court. He was arrested in a bomb blast case by the near. That is case number, special near case number 2 of 19, my lord. And he was arrested on 18/5/2019, my lord. And then since then he was languishing in jail. And now on 9/6/2025, my lord, the near court, my lord, special judge near court has allowed me to go on bail, my lord. And that the order you'll also will find at page 32, my lord. And after I have submitted my bail bond the next day, that is on 10/6. Immediately after I was released on bail, I was taken in custody in connection with Tongla PS case number 59 of 24 under section 5 of Explosive Act, my lord. Rate with section 18 of the Unlawful Activity Act. 11/6, but I was taken by the police.
59 of 24.
Yes. Now they have submitted a boarding report, your lordship. That is on page 47, man. The grounds of arrest that they have stated, my lord. That Senior Law Court so-and-so is our court so-and-so having association with Ben Alpha and was previously arrested. They have admitted that I was in judicial custody in connection with RC case number so-and-so, raid with so-and-so, so-and-so, so-and-so. That is admitted, right? In investigation case, it is found that while the key mastermind of the case, Dumon Bora, who is already bailed, was in the process of raising a new second armed extremist outfit in name and style Revolutionary Front of Greater Assam. He was in touch with a veteran Alpha leader, so-and-so, and the present petition who was lodged in general jail and similarly conspired with Junmoni. And furtherance of the said conspiracy, they informed Junmoni Bora that the 2 crores of cash collected by Alpha cadres by means of ransom was kept concealed in Naga Ali Forest of Sibsagar district. As per the instruction, as Junmoni Bora had launched a such operation in the said forest in August 24, Junmoni Bora was planning to use these 2 crores to procure arms and ammunition from RPG by using their Alpha contacts, and Sinma Vijay were providing outside support, but we were planning to join it after getting sent out from central jail. Vijay and Asma, although lodged in central jail, that is important. They maintain license with Jumon Bora either through physical visits or through SMS and phone call. This shows that now you're lodging, my lord. In a case when a person is detaining you under in a case of unlawful activities, nobody is allowed to meet. We have to take permission from the NIA court. That is a provision. Even if parents have to make a special application before the court, then only jail authorities will allow him to. The visitors are not allowed to meet them. They are kept in separately.
So this is a blatant, actually false statement they have made it. They, same as phones, the question of phone call doesn't arise because when personally they don't know how can I get make SMS phone call? It is quite an absurd story, man. This shows as Vijay
But that must be happening,
no,
though law does not prescribe.
because I made a statement, my lord, in my way. Because as a father, whenever we used to go there, I have to take permission from the court. And court allows me to and give, then only they may allow to meet me, man, meet my son. Man. Otherwise, they don't allow. As director, the Junmoni Bora arranged to supply so and so, color so and so, it appears that they are planning to. So these are all based on presumptions they have studying that. And they have made a search in the amount was also could not be recovered, my lord. Nothing was there, my lord. Now my question is, my lord, basically on one law point, my lord. First of all, that when I was in custody, there is a decision of
You were in custody in case of Nia case.
Nia case.
Nia case number?
Nia case 2/19, my lord.
19.
19. Now, there is a decision of real, as your lordship has also gone through, my lord, that is Uday Chin versus Sheikh Mohammed, my lord, reported into 1983 to SSC, my lord, where he stated, my lord, that if an order of bail is passed by us, the authorities were stated considered it fit to arrest any petitioners or any other offences. It was a bounden duty to apprise this honorable court before taking this person in custody, especially when no disclosure was made to us when we passed the order of bail, as the case or cases be under investigation. We regret this elementary of courtesy to this court was not shown. The petitioner shall be treated as a free citizen in spite of the fact they have been subsequently arrested, which arrests are contrary to the order of bail passed by this court. That has been, because, so it was a bounden duty of the investigating agency to inform the Nia court that these are the cases pending against me, man. But they've never disclosed at any point of time, because from the case, from the forwarding report, it appears that according to them, this conspiracy, alleged conspiracy took place way back in the year 2024, man. What they have said while I was in custody. If that is so, my lord, is it not the duty of the investigating agency to inform the Nia court that these are the materials we have found that he is also involved in this case, and these are the sections there he is involved. So, and in fact, there is our Kamal doctor, my lord, in a similar case, Justice Bhuya, my lord, while then in 2015, my lord, they passed a similar judgment, my lord.
You have a copy of that?
Paragraph 22 and 24, man.
Yes.
Article 22 of the Constitution of India deals with the protection against arrest, detention of certain, while clause and 1-2 deal with arrest, second part deals with preventing detention, which the present case is not concerned. Clause 1, no person who is granted, who is arrested shall be detained in custody without being informed as soon as may be the grounds of such arrest, or shall be denied the right to consult and to defend by the legal practitioner of his choice. Clause 2, which is relevant, provides that every person who is arrested, detained in custody shall be produced before the nearest magistrate within a period of 24 hours, excluding the time necessary for journey from the place of arrest to the court of magistrate, and no such person shall be detained in custody. Make it eminently clear. Requirements under said clause is that no person who is arrested shall be detained not to produce so and so. That is regarding production. Now coming to 24, that apex court decision, my lord. In Uday Singh versus Sheikh Mohammed, so the apex court deprecated the practice of withholding information to the court about the requirement to arrest the accused in other cases. It was held that even after order of bail is passed by the court, authorities of the state consider it fit to arrest a released person for any other offense. It was bound in duty to apprise the court before taking such person. And the facts of that case, the arrests were held to be contrary to the bail order passed by the apex court, and according to petitions of the cases were released from custody, treating them precedent. Having regard to the above law, so and so, to be released or this continued detention is clearly untenable, and notice he has been granted bail by this court or out of 4 cases, that is Pasigat so and so. So she shall be released in bail in connection with other 3 cases. So and so. So that is the law actually prescribed. And it has been followed by our High Court also, way back in 2015. So in this present case also, Admittedly, I was in custody. And they know it, I was in custody. It is that they are not ignoring. And they want to make a case of conspiracy that while I was in jail, the LS occurrence took place. Is it not their duty to inform the NIA court that these are the things that is involved in such cases?
Suppose an arrest is made without informing, then
Then the arrest is illegal, man. It
arrest
amounts
is illegal
illegal, man. Because
because of this.
because of the Farooq Abdullah's case, my lord, arrest is illegal, man. That is followed by our High Court, my lord, in Kamal Doctor's case, man. When the prosecuting agency knew it very well, that I was detained in another case. So there is the duty to inform that court that these are the case pending against the man. As a basic right of an individual, man.
Yes.
We cannot deny it.
The basic contention is when he was in prison, a different case was filed where he was an accused in which his arrest was necessary. You did not inform the court, but as soon as he was released on bail on the next day,
No, the same day I was taken to Anna Mila local police station. man.
on the same
Thereafter I was
day,
taken to Tonglam.
he was arrested. This is illegal. What is your submission?
I am not preparing on that line, Lordship, but I will definitely do that line on that line, Lordship. But I have to point out some other things also, Lordship.
No, on others, he is not pressing.
Lordship.
Other things, facts I'm not coming, facts I will also come, my lord. Letter number, first of all, if there is a violation of law, my law laid down by Supreme Court, my lord, they are entitled for bail, my lord. And that has been deprecated by Supreme Court on a number of occasions, so you cannot do it, my. They do in,
Case diary is there.
If it is there, Lordship.
and moreover, the grounds that has been shown also, your lordship may kindly see, that while I was in jail, I was making contact, my lord, to SMS, so and so. Whether phone calls, nothing records are there, my lord. And without the informing that no person is allowed to meet any detainee, my lord, any person arrested and.
No, what is your submission? You need time or what?
Otherwise, embargo is there, Lordship. 43 days there. Otherwise, embargo is there.
And because
Prima facie material is there.
Whether it will overcome 43 days.
necessarily will overcome my. Whatever the case is there, but they have to inform me the court, my. Because I am arrested in another similar case, my. Is it not their duty, my? Because 43, my lord, only a way of conspiracy I was brought in unlawful. Otherwise, there is no material of conspiracy, my.
Moreover, one prayer is made before the Honorable District and Session Court of adding 61 Lordship of BNS. There is criminal conspiracy. Otherwise, it is also there, Lordship.
Here, it is not observed that it is violative of any. It was observed that it is violative of the bail orders passed earlier. That the arrests were held to be contrary to bail orders passed by the apex court. The
Yes.
bail orders passed in NIA,
Nia case.
in this case, in NIA case.
Nia case, because Nia case, I was arrested in is also there is unlawful activity act, my lord. I was facing trial.
No, you have to let him go through. And you have to address, how will you overcome 43?
43, my lord,
The-
43 also, but for my, whatever forwarding report they have submitted, my humble submission, sir, no primary facie case has been without. Because the very conspiracy that they want to say in the jail. That I was having conversation with the main accused. Because physically I cannot talk with them, my lord, without the permission of the jail authority, court, my lord, near court, I cannot.
And what is your response to that?
Lordship.
When I am
What is the evidence? You
Lordship,
need
there-
not to answer now.
Lordship.
We are fixing a short date.
You also may kindly see, whenever a person is arrested, detained in a case of unlawful activities, it is the court who has to give permission. Otherwise, nobody is allowed to meet. They have segregated from the other trial prisoners. Totally segregated. Nothing, full, nothing, man. So this is never, it is quite impossible, man. The story that has been made out in the foreign report that I had tried to contact with so and so. That too in the year 2024, man, because he was arrested in 2024.
When will you respond? Let him come.
let him-
On 8 Lord.
Heard Mr. P. Kotoki, learned counsel for the petition. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner submits that arrest of the present petitioner in connection with
Tongla PS.
Tongla PS case number 59/2024 under section 5 of the Explosive Substance Act, as well as 18 of the section 18 of the Unlawful Activities Prevention Act 1967 is violative of the guidelines of the Apex Code in the case of Uday Chand versus Sheikh Mohammed Abdullah, Chief Minister of Jammu and Kashmir, reported in 1983 2 SCC 1983 2 SCC 417, as well as the judgment of this court in the case of Kamal Datta versus Union of India and others, reported in 2015 SCC online. GAU 759. Learned counsel for the petitioner also submits that while the petitioner was detained behind the bars in connection with NIA special case number 2/2019, no outsiders could have met him without leave of the trial court.
Special Judge Niam.
That is Special Judge Nia. And under such circumstances, the accusation against him that he conspired with whom?
The main accused, my lord, that Juman Bora. That is your lawsuit find at page Juman Bora.
Who is the member of?
He is a member of a new organization that is Revolutionary Front of Greater Assam, RFGA.
He conspired with Juman Bora, who is a member of Revolutionary Front of Greater Assam. Does not, is a false accusation. Stop. On this, learned additional public prosecutor submits that though the case diary is available before the court, however, he seeks some time to respond to the submissions made by learned counsel for the petitioner regarding the applicability of the judgment of Uday Chand versus Sheikh Mohammed Abdullah within bracket Supra and Kamal Datta versus Union of India within bracket Supra in the instant case. The time is granted. Let this, the prayer is allowed. Let this case be listed on 8th of August. Case diary shall be retained till next date.
39. May I please, your lordship? Only, my lord, 11.5 kilogram of ganja, hang lordship. This is a
73 years old man, I am granted interim. 11.5 only kilogram. Bhang, ganja. Lordship, on 20th of June, I was granted interim protection. And Lordship, accordingly, I appeared before the
Appeared.
Yes, Lordship. Appeared, bail bond submitted, it was accepted, but Lordship, what happened? I couldn't speak properly due to the age and nerve problem. Now, Lordship, statement not recorded. To my statement, even police said that in this situation, we cannot take your statement. So bail bond submitted and he is allowed to go. Now, Lordship, it is fixed today for CD.
Yes, Mr. Sharma.
May I pray that he may be granted absolute bail, Lordship, at this age.
Let us see what this.
Pending here from month of June it is here.
Yes, Lordship.
Yes, there is here. We'll extend your interim for one more time. Heard Mr. G. Samoa, learned counsel for the petitioner, who submits that the petitioner is on interim bail and has cooperated in the investigation. On the other hand, Mr. B. Sharma, learned additional public prosecutor, submits that the case diary which is available before the court is not updated, and he prays for calling for an updated case diary. The prayer is allowed. Let this case be listed again on 27th August.
27th of
August. The
DPO.
the interim order shall continue till next day.
Notice regarding notice, also will have to take instruction. There is an office not available.
Present petitioner does it, POCSO Act is not applicable otherwise. Against the petitioner, section 88 causing miscarriage is a bailable section. 89 causing miscarriage without woman consent. It is a
No,
non-bailable.
you have taken steps.
Already taken steps.
We'll wait for some more time. You find out. Case diary is there. What is to be done?
So we'll have to wait for very recently probably these steps were taken.
Heard Mr. L. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary is available, however, notice issued to respondent number 2 has not yet been served. Stop. Learned additional public prosecutor is requested to get the information regarding the fate of the notice issued to respondent number 2 from the officer in charge of the jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed on 11th of August.
Submitted.
You're on interim. You appear before the trial court. Heard Mr. What is the name? N. Kolita, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
143/25 dated 28/6/25.
Stop. In view of the fact that the charge sheet has been submitted, this bail and this anticipatory bail application is disposed of with an observation that the petitioner may approach the trial court and may file regular bail application before the said court, if so advised.
Wait, Your Lordship.
Yes,
This case I filed additional affidavit yesterday, Lordship, but it is not tagged in the record.
little,
For today, Lordship, it was fixed yesterday. They should have mentioned in the morning, Lordship, because we are having very urgent needed application, Lordship. The petitioner is an interim. This is in relation to that Bandhan Bank account, Lordship.
no, what is the submission?
My submission is, Lordship, may clear the matter, Lordship. He is on interim. Investigation is at a stall, Lordship, because of his non-cooperation, Lordship.
Oh,
Custody interrogation is necessary, Lordship.
what affidavit have you filed?
I have filed text, Lordship.
Why it is not there? Affidavit Matan Asin.
You can have my copy if necessary, Lordship. Without that affidavit also, the case can be here, heard, Lordship.
Then, Lordship, my senior is on leg in court number 3.
Your case may be weak case, perhaps. You are reluctant.
But her case. Delivery of order on 4/8. And the case that is also before your Lordship. Only this case, relating to this case, Lordship, on the last occasion, time was short, 1 week's time to file affidavit. Yesterday, it was fixed for filing of affidavit. Yesterday, they took time for filing of the affidavit by today. Today.
You have filed today.
Yesterday it was filed.
Filed
They should have
yesterday and
mentioned it
yesterday
in
in
the,
the
they should
Plaza.
have mentioned it in the earlier to take the affidavit, Lordship. They have not done that, Lordship.
We filed it yesterday in the FASA. We are thinking that it shall come the.
Okay, we'll fix it tomorrow. Heard Mr. R. Sharma, learned counsel for the petitioner. No, because other cases are fixed for delivery of orders on Monday. It has to be before that.
Chip permits. Time may be fixed, Lordship, because AB, it may not reach, Lordship. and-
At two,
Yes. I know that.
heard Mr. R. Sharma, learned counsel for the petitioner, who submits that the petitioner has filed an additional affidavit to bring on record certain facts which has not been tagged with the case record, and prays for an adjournment on that ground. On the other hand, learned additional public prosecutor Mr. B. Sharma has submitted that the case diary is before this court and the petitioner is enjoying interim protection without cooperating in the investigation. And this anticipatory bail application is required to be heard expeditiously. Considering the submissions of learned counsel for both sides, let this case be listed for hearing tomorrow, that is 1st of August 2025 at 2 p.m. The registry is directed to place the additional affidavit filed by the petitioner with the record before this, with the record on the next date of listing. Tomorrow at 2.
How I am cooperating with the.
Okay, let it come. We'll reserve it for tomorrow. Yes.
PRS bail, Your Lordship. Already she is on interim bail. And in terms of the directions passed by this court earlier, she has already appeared before the IO and recorded her statement. Lordship, if you find the FIR starts at page 9.
Case diary is there.
Keza is coming, Lordship. But Lordship, in similar matter, Lordship, another case was fixed at court number 24 as item number 19. It was rejected by that court, Lordship, today.
No, but what is the case against? Each case has to be dealt.
Similarly, one is Ananya Bhattakur, whose mark was also enhanced to get her selected, who was in merit list 104,
he was selected at CL number 3, Lordship, made question 3. Similar allegation, Lordship. I
Not
made
similar,
question
Lordship. The allegation is different in my case, in this case.
No, do you need his custodial interrogation? Whether he has cooperated in the investigation?
For he case Lordship, he appeared, Lordship. It is a fact, Lordship.
No,
But as per my instruction received from the prosecuting agency, his custodial interrogation is required, Lordship.
why? No, if he has appeared and you have recorded his statement,
There are certain things that I have gone through the material content against that Amanda Botaku. I am yet to go through that petitioner's involvement here, Lordship. Then the matter is fixed tomorrow, Lordship.
not tomorrow. You keep the case diary. Kali kiman cases. Next week, early next week. Let it be on 5th. You retain the case diary, will extend the. Heard Mr. Z.Z. Ahmed, learned counsel for the petitioner, who submits that the petitioner was granted interim bail by a coordinate bench of this court on 25/6/2025, and in pursuant to the directions of this court, the petitioner is cooperating in the investigation. On the other hand, Mr. P.P. Dutta, learned additional special public prosecutor, CM Vigilance, Chief Minister's Special Vigilance Cell, has submitted that though the case diary is available, however, as it is bulky, he needs some time to go through to see, before he makes his submission in this case. The prayer is allowed. Let this case be listed on 5th of August. The interim bail granted to the petitioner shall continue till next date. The case diary which is available shall be retained till next date. To return করি into return.
This is NDPS case Lordship. Yes, has been registered under commercial context. So the present petitioner Lordship, he purchased the vehicle from one Lordship Minal Pata on 29/1/2024. On the next day Lordship, I handed over this vehicle to my engaged.
21?
21, sorry, 29/1/2024. From one Minal Patok, I have another agreement, Lordship, this 16 is the agreement. Yet Lordship, I am not the registered owner, he is the registered owner. And agreement, Lordship, that has been made between this Minal Patok and the petitioner. Lordship, on the next day, Lordship, I handed over this vehicle, Lordship, 14-wheeler truck vehicle. Handed over one Mohidul Ali, Lordship, he was engaged as a driver. He, Lordship, went to Delhi with the certain goods, Lordship. And on 10/2/2024, he informed the petitioner that he is coming from Delhi towards Silchar with some onion to be unloaded in Silchar. Lordship, on 10th, after a week, he has come to know that that truck was seized by the police and some Lordship materials, Lordship, that is cough syrup. Lordship, 178 carton cough syrup were Lordship recovered from the truck. And subsequently, Lordship, the original owner, Minal Pathok, he filed a Jima petition for taking of this vehicle. That is also, Lordship, I have an exact order also. He, Lordship, the present petitioner is not yet the registered owner. He just passes the vehicle and handed over to the driver. And driver has, Lordship, done that incident.
Yes.
My lord, yes.
the truck, driver of the truck fled away. Driver of the truck fled away, leaving behind the truck, matlab, and the petitioner, matlab, as per the agreement, now petitioner is the owner. Though registration is not changed, because by the agreement, he has purchased the truck from the original owner, and the driver not yet arrested. Main thing is that driver not yet arrested, and from the truck, matlab, 17,800 bottles of cough syrup were seized. Along with 750 kg of onion. Onion was kept, and behind the onion, are bottles of cough syrup. 17,800 bottles.
How he is involved?
Matlab, how he is involved? As per maybe as per his instruction, driver is bringing those. If driver is arrested, then it can be revealed from the driver also. But driver is also fled away. And now, as per the agreement, he is the owner of the truck. Though not registration is not yet changed. So, matlab, there is, and he is seeking anticipatory bail because of this. Matlab, driver also fled away, and
So apart from the fact that he is the owner, you don't have any other incriminating material. Nobody has implicated him.
from the we come to know that this now is the owner of the truck, and that is the thing.
Except this lawsuit, nothing is there. Because
But
bonafide purchase are lost.
driver matlab has bringing those items from Delhi to Imphal without his instruction.
Only suspicion.
The suspicion is there, matlab, and huge quantity. Matlab. That is
How will you overcome 37 embargo?
Whether the petitioner lordship has any involvement in the incident lordship. The trial lordship, admittedly, this was driven by one Mohidul Ali lordship. And he fled there. Still lordship is hiding. He is not found. Only one day lordship on 10/1/2024, 10/2/2024, he informed that he is coming from Delhi towards Silsor for unloading the onion. How my friend can say that he has instruction to take that?
He may, I have said that he may. There are conversations between the driver and the owner. And without his instruction, that is taken by the driver.
It is not a fact that from the home district or home place of the petitioner that was loaded and went to Silsor. It was loaded from Delhi lordship. Agent petitioner lordship is a bona fide person. He is supposed to pay the installment lordship per month lordship 91,000. That's why lordship after executing the agreement, lordship pays 16 is the agreement lordship.
No, in NDPS cases, anticipatory bail
Sir.
has to be granted only if there is no reasonable ground for believing that. So if there is some incriminating material, if there is,
Driver said no.
but you could not arrest the driver.
Driver also fled. Driver, if you get the truck, driver fled away.
1.5 years.
Okay, likelihood he may get anticipatory bail. I'll go through the case diary.
Because otherwise the case is very serious. Unless lordship the situation is not there. So I could not have filed this.
I'll pass the orders in the chambers. Otherwise, you are objecting on what ground?
He's now the owner of the truck, and driver also fled away, and huge quantity of contraband was seized from the truck. So there must be.
So, no, now from your submission, it appears that you are only suspecting his involvement. Apart from suspicion, when the truck was seized,
Driver is yet to be identified, and driver fled away.
when the truck was seized,
That was seized lordship on. I have given the seizure list lordship is
date, what is the date?
2020.
15/2/2024. So in this 1 year, you could not collect any evidence against him. Then he is likely to get anticipatory bail. I'll still go through the case diary. If there is nothing, he will get. If there is something, he will not get. Yeah.
Vehicle. Driver is yet to be identified. Now, Lordship, prima facie, it appears that the vehicle belongs to him. Lordship, the burden of proof, Lordship shifts to him to blame that he is not involved in this.
No, question of burden of proof will come later on. But in a case where bail is difficult to get, where 37 embargo is there, to arrest him there, you must have some incriminating materials.
In the
If there was a driver, unidentified driver, maybe Lordship, he is the driver. Who is to say, Lordship? He has been absconding for 1.5 years. He has not cooperated in the investigation. If the IO has seized the RC details, thereby they have found that he is the owner of the van. He has also some Lordship, he has also to satisfy your Lordship regarding his involvement in the offense. Lordship, this agreement is speaking about whether it is registered, whether they have moved the MV Act Lordship for change of ownership, whether what has he done, Lordship? How is he not involved in this offense? Primarily, he has to prove that aspect, Lordship. Only saying, Lordship, that I handed over the vehicle to some person, Lordship, that cannot be taken as its face value, Lordship.
So for ownership is concerned, Lordship, I have annexed on order, Lordship, based.
Okay, okay, I will consider your
Submitted the Zimba position.
I'll consider the submission. I'll pass the orders in chambers today. You give the case diary. Time is over. You have to wait for the remaining items. CD is there tomorrow. Monday, Tuesday. On 60, item number 62 on 5th. Due to paucity of time, the matter could not be taken up. Please this matter on 5th of August. The case diary shall be retained till next date. Interim will be extended wherever interim is there. Yes.
Regarding the Sonapur matter, Lordship.
Case diary I have returned. That case diary, you want that? Tomorrow morning I will give it. You have to again give it back to me because I have not prepared the orders. Yes. Item number 46. What is your prayer? You have to be louder. (46) will be left over. Registry will fix a date. Criminal petition. It will be shown as leftover matter. Registry will be giving dates. (44) case diary is there. Tuesday. 44 Tuesday.